Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and thank you so much for coming to join me and my special guest, Mark Bederow, today. Today's Thursday, November 14th of 2024, and I knew that everybody would want to hear Mark's thoughts about Hank Brennan's debut yesterday at the Karen Reed hearing, his first appearance, which I vented about a lot yesterday. I barely have any voice left, so I thought I'd give Mark a chance to come on and vent with you. And I know that you have questions. And then we also need to go over the new motions that were filed yesterday that Brennan said he was going to file. Got them all. He filed a couple of Rule 17 motions and a couple of Rule 14 motions. The judge made some orders. We're going to talk about all of it. So thanks for being with us here today. Let me bring Mark on so he can say hello and we can get started. Hello.
How are you?
I'm good. How are you?
Okay. What's up?
So nice to see you the other day.
Yeah, that was interesting.
Wasn't that fun?
Yeah.
If you don't know, Mark, I ran into Mark at the criminal court building in Manhattan. I was there to sit on the Daniel Penny trial, and Mark was there with an actual case and actual clients and other matters in the building. So that was a lot of fun. 13th floor of 100 Center Street. It's a pretty rocking place. We saw Judge Jeanine Pirro. I saw her out there, and Sandy Rubenstein, he was there, and you just froze up on me. Wait, are you there? Did he freeze up for you guys too?
No, I'm here.
Oh, you know what? Maybe refresh your browser.
Okay.
And I'll be here. You refresh your browser. Did you guys see him freeze? Or was that just me? And then he'll come back in a minute. StreamYard is having a lot of issues. There we go.
I'm here.
All right. So did you have an opportunity? I know that you're very, very busy with a lot of other matters that have nothing to do with this case or even with Aiden's case. And so I don't want to take up too much of your time, but I know that we should, everyone wants to hear your thoughts on the debut yesterday on whether the hired gun is as stellar as everyone thought he was going to be. And, thoughts, concerns, things that you noticed that I had the chance to vent about yesterday.
I did watch it, or 30 minutes of it, or whatever it was over lunch. So kind of in the background. It was kind of a nothing really. So it's hard to draw a lot of conclusions. It was pretty, I don't want to call it a waste of time, but when you file motions that can't be heard. Oops, I lost you. Did I lose you?
Oh, no, I'm here. I think you keep freezing and I'm not sure why. Are you hooked onto the internet or the Wi-Fi?
Home Wi-Fi looks good.
Okay.
Anyway, what I had said was, if you're scheduled to present motions, but you don't serve all the parties, which requires everyone to have to come back on a case of that magnitude with all the people lawyers from California. I mean, that's regrettable. So I'm not sure how that was surprising that
Yep.
had been taken care of. As far as everything else that happened, I don't think anything else did happen. It was just kind of a waste of time. They have to come back multiple dates. He said what he said. Some people were online commenting about his voice. I think that's a little unfair.
Yeah, no.
It is what it is. He is who he is. I don't really take much out of it. I mean, he did keep saying the government, which, I mean, this is real lawyer inside baseball. I understand that, but the government is the U.S. attorney, not the state prosecutor, who would be the Commonwealth in Massachusetts. It would be, the people in New York, or I usually say the DA. You don't usually hear on a regular basis the state prosecutor referred to as the government.
Well, what he did was he misrepresented. He's a defense attorney. So when he says, the government and the prosecutor, that's what he normally says. That's what he froze up on me again. You may have to refresh again. I mean, like, I can hear you, but your face is freezing. Because he said, in the first trial, the government hired a dog bite expert. He clearly meant defense. He was talking about Dr. Marie Russell, because now they want a Daubert hearing, and they've already had one on her.
Well, that's part of the whole, this case is from the upside down, and you have a defense attorney being the prosecutor, and he literally flipped the names, and it's because it's hard. He's not used to doing this, at least for some period of time. I mean, that was clearly just a mistake, but it also emphasizes how, in many ways, absurd it is to have anybody really from the outside come in and try the case, because no one in the office is either willing or capable. So that's bizarre. I think it's not knowing the names of these witnesses that you want to have a Daubert hearing for. It's not a great look. You've been on the case 3 or 4 months. I get it. Not having reviewed the trial, which would seem to be one of the first things that you would do in reevaluating the case. I thought that was a little surprising, particularly in light of some of the stuff that they have going on, which appears to be much more in the weeds, much less important than, I don't know, seeing what the witnesses said under oath at the first trial, which would strike me as probably the single most important thing to do in evaluating what's happened, what should happen in the future, and whether this is credible and I believe it. So I thought that was, to me, the most surprising thing, was that 3 or 4 months into this, not having reviewed the trial in its entirety, saying
it's on YouTube.
It's on YouTube. It sure is. And there are transcripts now too. You don't even have to watch it. You can read it. I mean, it's what lawyers do. You read transcripts all the time. So, some of that was kind of surprising. The stuff with the experts, I mean, you knew that was coming, and he did concede in some sense that his expert biffed hard on bytes and bits and megabytes and megabits and gigabytes and gigabits and stuff I don't understand. But that's not a great start for an expert who literally screws up the calculation, and he's the person that you're going to entrust to do this apparently very difficult scientific process and procedure. If he testifies, his credibility is already severely problematic. I mean, he's absolutely going to get cross-examined about your first report, affidavit, whatever, out of the gate was screwing up very fundamental aspects of that expertise. I mean, again, someone like you or me might not know that difference, and you would say that makes sense, but
that's why we hire experts.
Why you hire experts. They're supposed to know these kinds of things, and it doesn't mean that he's an unintelligent man or whatnot, but for them to poo-poo that and say it's not a big deal, I have a strong feeling a lot of jurors are going to disagree and say, well, if the guy doesn't know bytes and bits, is it because he's not technical enough? Is it because he's not careful enough? Is it because he didn't read the data carefully? It could be any number of things, but either way, it looks bad. It just does.
Not a good look. Here's the order. She already ruled on it, of course, immediately. This is the first thing that she did was she signed their proposed order, the Commonwealth's proposed order, and just crossed off proposed. So made it the actual order to examine the telematics system. And so we'll just read it. Upon review and hearing on the Commonwealth's motion for reassembly and additional testing of defendant's Lexus telematics system, it's hereby ordered that testing may occur to acquire the vehicle's data. It's hereby ordered that should the defendant seek to have their own expert present for testing, they provide the Commonwealth the name and contact information of their expert within 5 calendar days. So she signed that immediately after the hearing. Why she couldn't just rule on it at the hearing and then say, I'm going to sign the order, from the bench. Why she couldn't say it from the bench is beyond me. It does not say in this order something that they talked about or argued about was whether or not the defense expert was going to be allowed to intervene or participate in the testing or was just going to have to observe. Because the first time this testing happened, Mr. Jackson pointed out that the reason that the defense expert had to do the chip off is because Trooper Paul was like deer in the headlights, had no idea how to do it. So tell the viewers what typically happens in a case like this, where the defense brings in an expert and the Commonwealth or the state is in charge of testing the evidence.
Well, it is not common for the defense to say we want to literally stop the process because we potentially may find that your expert is just not competent. I mean, this is another part of the whole upside down nature of all this. The fact that it's even being credibly discussed that we don't trust your person based upon bytes versus bits, and you could destroy. I mean, they're concerned that they could destroy the data, and the guy that they don't have much confidence in, didn't know the calculation. So to me, I scratch my head and say, well, why aren't they doing a Daubert hearing on this guy before letting him come in here and let him get examined and let him explain, how did you screw up the bytes versus bits? And maybe he just says, I misread a capital G and a small g, and who knows. But if we're in the, if we're doing Daubert hearings for everything, including witnesses who have already testified and been approved by the court.
Well, yeah, another question for you. Why did they get a second bite of that apple? They did a Daubert hearing on Dr. Russell. They did a voir dire of her right in the middle of trial. Remember, they sent the jury out. They did it. She was qualified.
I don't know. I mean, obviously, the prosecutor said yesterday that we think that the witness, I mean, he apparently saw that part of the trial. The witness was not qualified or had the wrong expertise, and they want to challenge that. And I thought what was interesting was that the judge just kind of rubber stamped it and said, well, then we'll just do a Daubert hearing, as opposed to what exactly do you.
Oh, lost you again. Hold that thought until I hear you back again.
Oh.
Okay, you're back. Yeah, like, why do they need it? They got a flyer in from California. And then you heard the whole thing about, Mr. Jackson, can't you take the red eye?
I guess what I'm saying,
my mind.
What I'm saying is, I don't know why the judge didn't ask for, I guess what you would call an offer of proof from the DA and say, what's the problem? She's already been cleared, and you say that she's not the right person or lacks the right skill or whatnot. What's the problem? Tell me why.
Yeah, tell me why you don't think that she's qualified again. You did freeze up again. I don't know if this is StreamYard. I don't know what this is going on here. I don't know if too many people in your house are eating up your Wi-Fi. Okay, start again. I don't know why the.
I don't know why she wouldn't just say, tell me why I'm going to rule different, and why am I having them haul a witness in from California, bringing the lawyers back for California, but no one's concerned apparently with the credentials of a guy who is found off the internet, who doesn't know apparently the difference between bytes and bits.
There you go again. There you go again. StreamYard has been very uncooperative lately, Adam, but it's only on his end. It's not on mine. So let me see. Let me refresh my browser and see if that solves the issue. So everyone who's watching, just hang on, because it's going to take us a minute. Mark, you may have to log back in. I'm going to try it on my end. And I'm on the Ethernet with FiOS. So let me just refresh. Everyone, stay tuned. We'll be right back. All right.
Okay. So I guess what I was saying was I don't know why a guy who apparently had an issue with calculating really basic measurements for that skill is not the kind of person whose credentials and thought process should be challenged before a judge is going to allow him to do anything and to hear and offer proof what you expect his testimony might be to determine whether he's ultimately going to be allowed to testify or not. But I guess, that's just not the way it works.
Well, now that she has granted the order, maybe they can make that application. That
Well, it
before any
sounds-
testing happens.
Well, I
Yeah.
guess, he can do his testing and make his findings, and they'll certainly be allowed, based on what his report is, to make an argument about whether it's relevant, whether it's not relevant, whether it appears to make sense. I mean, again, the defense expert will file a report, and it's not like they can't challenge this again, depending on what he finds, what he did, what he concludes. But it's just surreal to me that there was 10 minutes out of a 30-minute hearing on, the case of the century, where there was a serious discussion with straight faces over an expert who could not calculate those things. And the defense is saying with an absolutely earnest, straight face that we need to babysit him and have the right to call a timeout and address this because we have that little confidence that he may do this correctly, such to the point that they could destroy whatever is on there. And I think there's two things you need to take away from it. Putting the Twitter lawyers aside, who have already determined that all of the evidence on this telematics machine is going to prove Karen Reed's guilt. It's going to show that she mowed John O'Keefe down. It's probably going to have a recorded confession for everything she's done in the last couple of years and give a blow by blow, everything. It's the whole case is going to be wrapped in that. If you believe them.
Well, their best theory is what they think it's going to show is that she went back to the scene at 5 a.m.
Which
that's what they think it's going to show.
I don't know why that would be that big a deal, but the point is, even the prosecutor has acknowledged, as he should, to his credit, could be exculpatory, could be inculpatory. But the real takeaway from this is you heard Alan Jackson yesterday very clearly saying, do it. We're not against this, but we want it done right. And we don't trust this guy to do it. So again, to the Twitter lawyers and those who just believe she has to be guilty for everything that has ever happened in society, at least get your facts straight. The defense is head first into this saying, bring it, let's do it, but let's do it right. And we don't trust the Commonwealth of Massachusetts to do it correctly. So I thought that was an interesting takeaway. They are very much all in on the results and hoping they get it.
Right. All of the Twitter lawyers were saying, why are they opposing this? Why are they opposing this? They shouldn't be opposing this. What are they afraid of? They did not oppose it. They did not. They want the information too.
But even if they were opposing it, again, and this is a Twitter problem, people don't understand what the role of a defense is. They don't have to prove anything. There would be nothing wrong with the defense saying we don't want this because they're not in the habit of having to prove anything. The burden is on the prosecution. And if there's a way to deprive them of evidence that they don't get, that moves the ball forward in a reasonable doubt situation for the defense. So that would have been a perfectly normal and logical tactical advantage, such as, for example, a defendant who doesn't testify. Why wouldn't they testify if, they didn't do it?
Right. Well, how come they're not declaring their innocence from,
And again, and that's why you need to understand when you follow the Twitter lawyers, they don't have any fundamental understanding of due process, burdens of proof, and how a criminal trial works. And it's this case, said this before publicly online, is not about whether Karen Reed did it or not. That's really not even the issue. The issue is whether there is proof beyond a reasonable doubt that establishes her guilt to each and every element of whichever offense. And even if a jury were to believe she did do it, if they don't get it to that level of proof, then she's not guilty. And that's the issue. Is she guilty or not guilty? Not whether she did it or not. And all of these Twitter arguments always revolve around, she did it. No, she didn't. Yes, she did. Right. And when these people are so adamant in telling you all this evidence that proves that she did it, the proper response for other people has to be, tell me why there's no reasonable doubt. That's wonderful that you've established what you believe are facts that are consistent with her doing it, but you can't avert your eyes to all the other troubling facts or lack thereof, which all point the needle towards reasonable doubt, which is what this is about, or the lack thereof.
Right. And, there's a question about whether people understand reasonable, whether the jury understood reasonable doubt. That's a whole separate, we could talk for 3 hours on a show like that. What I also found to be interesting is just basic procedural stuff, and basic like optics things that went on during this hearing. Like, for example, you are now the special assistant district. You are the hired gun. You are the blessed. You have been anointed to come in here at extra expense to the taxpayers of the county. And by the way, he brought on his own paralegal too. And now you're the guy. You are the man. And you get up to argue, and you have your back to the defense team the entire time. You don't see the need to go to the podium and address the court like as if this is a really, important proceeding. I thought it was a bad look, because the camera, we never saw his face the entire hearing. He's got his back to the defense team. You know how weird that setup is, because it's like the Commonwealth's bench is attached to the judge's bench. Like they are one, And when you get up to argue, how about you get up to argue? You go to the podium and you talk to the judge so that we can all hear and see you, and so that the defense can hear and see you. That was one issue that I had. The other one is basic procedure. A Rule 17 motion is a motion to obtain third-party records. And we did this pre-trial for the first case where I believe it was a whole hearing had to be rescheduled because the third parties weren't served. Exact same thing happened. So how do you come on board knowing or not knowing? And how does Lally say, did you serve the third parties? How does he not say that? Like, did you serve Verizon? Did you serve Vanity Fair? Because we saw the hearings where Boston Globe came in. I don't know if they asked for Vanity Fair yet. They will. But Boston Globe came in to defend Gretchen Voss and, reporters in general and, First Amendment. And we know we have no privilege here, but they said it was off the record. This is not their first rodeo at the Commonwealth. So how they didn't understand what needed to be done procedurally to get these motions heard on that day is beyond me.
So a couple of the three things you mentioned, you mentioned the paralegal. So the first question that I would be asking as a taxpayer or concerned citizen is, who's paying the paralegal? Is that part of the $75,000? Is that an extra amount? How is that happening? And did the taxpayers sign up for that too? Whatever. I mean, this is all part of the problem of this, what appears to be virtually unprecedented situation where you bring in a private ringer while the, defrocked prosecutor from the first case is sitting right next to him, twiddling his pen, also collecting a taxpayer salary to apparently do nothing the second time around. The other thing that I find interesting, and this is again part of just the absurdity and everything that's wrong in this case, is to Brennan's credit, he did go out of his way to make it abundantly clear. I'm going to give him everything I find. I get wacko emails. I'm turning it over. I'm not guided by the strict rule of Rule 14, although he said something that was inconsistent, which is I'm going to turn over whatever I'm obligated to turn over. Well, that's Rule 14. If you're going beyond it, you wouldn't be obligated. But I don't think he meant anything by that. I think the point is he was trying to say, I'm going to be transparent, which only begs the obvious. The guy sitting next to you wasn't. Okay. Stuff was not disclosed at the first trial. It came, as David said, it came in the middle of trial. There was this, fake evidence that was inverted, that was played during the trial, that was turned over during the trial. So to have to be Lally and sit there, how humiliating must have that have been? But that's also part of, I think, the dichotomy here, that the new guy who has to collect other money, had to be brought in as a ringer, is the first one, at least, to say, I'm going to try to do this straight. And we'll have to wait and see. But I mean, if you take him at face value, he said the right things. I'm just going to turn over everything. And in his mind, it's going to take me time to do that. and, I'm going to bait stamp it. And that was another slap at Lally. Okay. Bait stamping, for those who don't know, Bates is a company. So digress for 1 second. It's Bates, Bates, with an emphasis on the S in Bates. I do not know why in their filings they keep talking about bait stamping. There is no such thing as bait stamping, and the lack of editing that goes into these filings is another.
Oh, yes. Did you like the engagement letter that was attached to the CV of the new expert, which I want to talk about too?
It's just weird because I don't want to get too far off point, but it's a high profile case. Everyone's digesting, reading this, and typos happen. Every lawyer does it. I do it all the time. You get, muscle memory in your eyes when you're editing, and you miss things. But what you don't miss are things that are not real words that spell check would prompt you to say engagement is engagement, like something like that. That's inexcusable. That's sloppy, and I think it's a bad look. It's not going to change the outcome of the case, but if you're bringing in a new team to clean this up, then clean it up. It's bait stamping, but it also, again, emphasized that Lally's disclosure method in the first trial was just throw stuff at them, and there's no method to this. Like, to keep track, the purpose of bait stamping is every page is numerically logged so that you can say, go to, Bates 147, and there's a record of it. And, in the old days, as people would literally clink.
The rubber stamp. Yeah. I mean, the metal one.
Today, it's just part of a PDF program. I mean, the computer does it. So it's easy. And why he wouldn't have done that for a trial in, 2024, given the amount of materials they had, that was weird. As far as
could you imagine his desk with exploding red wells and paper everywhere, and nothing is stapled and all out of order? I mean, that's just what I'm picturing.
Well, that's kind of like how the table looked at the first trial, whereas, the defense table was a very clean, nice looking. I mean, people have different styles. As far as the courtroom layout, I mean, it's kind of like a hybrid federal courtroom which I hate that setup where the prosecution sits in front of the defense, but it is weird that their table is literally ajar to the bench in that way. And the optics of it are also, I think, what you said, weird, how what you see on camera is a prosecutor's back with his back to the other party. A lot of lawyers do speak at the table, but I agree with you in that situation. It would have made sense to go to the podium in a courtroom like that. I don't know what to make of it other than it's just, it wasn't a great optic. And if we're trying to, again, make this more of a real trial with real lawyers, probably the podium would have been better. The Rule 17 thing is shocking. It's not exactly rocket science in a legal sense that when you have papers involving third-party subpoenas, that the third party has to be served because they may want to be heard, and they have a right to know what the hell is going on when you're going to tell us what we're obligated to do. And the fact that this happened previously with Lally.
Yep.
Now, if Lally is truly part of the team, they didn't, before they got to court and file these motions, say internally, okay, did anybody serve Verizon? Did anybody do this? And, are they talking to each other? I mean, it comes off looking very disjointed, very disorganized, and it's not a good rollout. I mean, if you add in the typos in the filings that are, again, non-spell checked, if you add in the, bytes versus bits, that's your expert that you got off the internet. You add in the Rule 17 thing where you're basically asking the judge, what do we do now? None of this is going to matter in the grand scheme of what happens in the outcome. But first impressions, you only get one chance to make a first impression. And they have built this new prosecution team up, whether it's on Twitter or in the media, as if the new prosecutor who's coming in for the Commonwealth is Kaiser Soze, who's just going to come in and, nuke everyone with this incredible, never seen before skill set that's going to make everyone just run away and say, where do I plead guilty? And I wouldn't judge everything by yesterday, but if you're judging first impressions, it came off clumsy.
And the judge was annoyed. The first thing she said when she asked him, have you served the third parties? And he was like, oh, no, I didn't want to presume that you were going to hear the Rule 17 motions today. And she looked at him and said, I thought that's exactly what we were doing here today. But she was a lot kinder to him than she was to Mr. Jackson about why he couldn't take the red eye. And then at one point in the hearing, Brennan says to her, okay, Your Honor, I have some more Rule 17 motions that I'm going to file. And she said, notice them for the date. And he's like, well, should I tell them the date, or are you going to tell them the date? Or like he just doesn't understand procedure. And she said to him, Mr. Lally can help you with that.
Yeah. I mean, I first of all the lawyers in the courtroom, they've been lawyers admitted in Massachusetts for umpteen years. So I don't know what's going on with all of that, but to me, the interesting part of it is Lally. I mean, he's there. He knows how this works. That's his hometown court, for lack of a better term. That's where he's probably in front of that judge all the time. He saw what happened in the first process, and are they not communicative in terms of preparing? I don't know.
Or is he setting them up to fail? Jonathan, who's one of my behind-the-scenes paralegals, says that Brennan's working out of his own office and using his private staff.
Again,
if that's true, is that odd?
Well, all of this is odd. It's not normal to have an attorney in private practice taking public funds to prosecute, which is a government function where the government office is not being recused for a conflict of interest. He's not a special prosecutor. He is a ringer. I don't even mean that in a disparaging way, but he is an absolute ringer. They brought him from the outside because there's nobody in the inside willing or capable of doing it. And if he's using his own staff, I don't fault him for that. I don't blame him. Why would he want to use the DAs? Use your own people. But again, who's paying them? To me, is the question. Between paralegals and other things, is there a good government group who's asking questions or monitoring how these people are getting paid or why this is happening? And to this day, as far as I know, no reporter has ever asked Michael Morrissey, who is, being challenged for the first time in what feels like 40 years. Why is Hank Brennan there? And that's not a shot at Hank Brennan. He's probably a much, much, much better lawyer than the previous lawyer on the case for the DA. That's just the way it is. Lawyers are at different skill levels. So kudos to him for that. But the real question is, why is he there? I mean, you have a large DA's office who are funded by the public and who their job is solely to prosecute these kinds of cases, and none of them are. And as far as I know, no one has really asked that yet.
Vanity Fair asked it, didn't it? Wasn't it in, I don't know if you read the Vanity Fair article that was in two parts. It said that none of the other district attorneys in the office wanted to touch it, including their number one guy. And his name escapes me right now. Maybe Greg. I
think his name is Connor,
Connolly.
Or I could be wrong. Something like that.
Yeah, similar.
Yeah, that's my dogs in the background. Sorry. But even then, the follow-up question is, well, if none of your people are willing to do it, the question for Morrissey then becomes, well, maybe you should look in the mirror and say, what the hell am I doing and why is that? And doesn't appear to be doing that.
I mean, in addition to the manufactured inverted video that came in for the first time at trial, also the screenshots of the text messages between Allie McCabe and Colin Albert, all of a sudden they appeared and they were allowed in. Like, that was just insanity. I don't think those were ever exchanged before the trial. So many shenanigans went on with evidence during that first trial that hopefully they can move at a time to exclude a lot of this ridiculousness that was allowed in. I mean, that Sallyport video is the perfect example.
Well, the Sallyport video is like a two-prong. Are you serious? I mean, clearly everyone's focused on the critical issue of why the hell is that not properly positioned? Why is it backwards? I mean, that makes no sense. And that's a problem number one. But I feel like there's another component of the Sallyport video that people are ignoring, which is that thing just showed up in the middle of trial.
That's what I'm saying.
Yeah, I mean, that's mistrial. I mean, you know this, in New York, that's motion for mistrial immediately as a Rosario violation and all those things. That's just an outrageous, and they were never held to account for that. They were never required to even explain, by my recollection, and if I'm wrong, someone will tell me I'm wrong again, happens every day. But I don't believe they were even ever had their feet put to the fire and said, how the hell do you explain this? How did you just get this now? And, there are rules of disclosure, which are well before trial. And in the middle of trial, you turn over what is critical evidence. And, oh, by the way, it just happens to be inverted video that flips the taillight and hides Proctor. I mean, it's kind of a big deal.
And people are appearing and disappearing out of frame.
Yes, the famous apparators, right?
And Yuri on direct says, yes, this is a fair and accurate representation. And it wasn't until cross that he had to admit that it was the wrong. I mean, I remember that. I mean, it literally was exchanged during trial. Like, I don't even know if that was the first time that the defense saw that video, was when it was played in court, because Yuri even did testify. Oh yeah, I just got this, a couple days ago.
His testimony was even worse about the flipping it around. By my recollection, he also got amnesia about himself and Proctor, who he confidently identified on direct examination. But after it became clear that the video, in fact, was inverted and something was wrong here, he kind of was less confident in saying, well, crap, that's me and that's Proctor. And he tried to say these were in different parts of the video, and they even put it together and said, guy, that's you. And, big mess.
He wouldn't admit it. Well, here's the order that came down yesterday. And here's another problem with Hank Brennan not having watched the trial, is that he didn't understand that there were many sidebar conferences that had to do with the jurors. And you and I were there on the day that some of the jurors were called to sidebar. And it happened at the beginning of the day before, testimony even started for the day. That was the day that Jessica Hyde testified and Trooper Paul's direct. And what had happened was the judge called at least 4 of the jurors to sidebar to have conversations with them and the attorneys. And it was in the morning, and in error, nobody told the court TV reporter, in his defense, the cameraman, nobody told him the juror was entering the courtroom. Somehow the juror got on camera. The judge ordered the cameras shut off for the rest of the day. So the poor viewers at home had to watch Jessica Hyde on a Zoom feed that was like underneath her neck. I mean, it was insane. So a lot of these sidebar conferences had to do with the actual jurors. So when they were arguing whether or not the sidebar conferences should be unimpounded, and here's the order on that. It says it's hereby ordered that sidebar conferences prior to trial and occurring during the trial that discuss evidentiary issues shall be transcribed and made available to counsel and the court. The court finds that good cause exists to extend the impoundment order for all sidebar conferences that discuss jurors or juror issues. So he didn't understand, because he was arguing that you should keep the list of the jurors' names sealed. He didn't realize that some of these sidebar conferences the jurors were at sidebar, which was kind of, I don't know that a lot of people picked up on that, but something that if you're going to come in as a ringer and try this case, you should be aware of the basic issues that went on. And that day, I think one of the jurors was excused based on what happened at that sidebar.
She was, and there's been all kinds of other controversies with other jurors after the trial, as we know. And I think some of those jurors might have even been involved in some of the stuff that was going on the day that we were there. I don't remember exactly, but yeah, I mean, the trial is theoretically going to start in less than or about 2 months, give or take.
Mm-hmm.
And it is interesting, but the prosecution seems like they really don't want to go forward in January. I mean, they will. I mean, if the judge tells you you're going forward, you will. But on the other hand, their new team was assembled, a couple months ago.
Yeah.
So in essence, they've had 4 or 5 months to get ready for trial. And I think it's important to recognize that, it's a big murder case. I get it. It takes time to get ready. But let's be honest, a retrial takes less time. I mean, you've seen this before. You're excising this. You're not doing that. I don't know what the problem is. I mean, I sympathize that they want more time. It's a murder case, or it could be a murder case. Who the hell knows at this point? But
I mean, they're purporting it to be a murder case.
Right. But she's not giving them any break, even as they're attempting to do all of this extra testing. And that's interesting.
We're also still waiting for the appellate issue to be resolved.
The wild card, because it's not going forward in January. If they order it back to her for a hearing, this will never go forward in January.
Right. So we're not going to get to see the sidebars. The attorneys will. And then Mr. Brennan said something to her that I also found interesting. Well, Your Honor, I need it unimpounded so that I can go, look at them. And she said, well, you're an attorney. You're allowed to look at the impounded materials, Mr. Brennan. So she did kind of school him a little bit, very gently, I thought. But
I mean,
again, he's not used to playing prosecutor. He's putting a different hat on. So we got to cut him a little bit of slack. But if you're going to hire a guy and pay him lots of money and explain to your taxpayers why you feel the need to do this, initial optics are not great.
No, I mean, again, it was, I don't think it's going to matter in the biggest grand scheme of this, but if that was the initial rollout for what you were told was Kaiser Soze, it wasn't great. I mean, it was a little dysfunctional, a little embarrassing. I mean, no lawyer ever wants to be in a position where you hire an expert and the first thing they do is screw up the most basic math, if you will, to what you're trying to do. I mean, right out of the gate, you're saying, why did I hire this guy? They'll never admit that. I mean, I think he's very astute and that's wonderful. And you'll make that argument, but privately, there is no way in hell that anyone involved in that prosecution is not saying, what the hell are we doing here? This is a joke. Are you kidding me? I mean, I submitted papers saying there's all this data that was not taken off because there's all that empty space. And it turns out to be just a math problem that any people.
That's the thing. It wasn't like it was just a typo. It wasn't like they just had, I don't know the abbreviations for gigabytes. One's a capital G, one's a small g, whatever. It wasn't just a typo because he extrapolated it out by saying, so therefore there must be this much more data in there that was not recovered. And so it wasn't just a simple scrivener's error or,
or four of them, as it were, related to another document, which I'm sure you'll talk about. But
yeah, if you want to get into that search warrant, we can in a little bit. So here's the other thing that they're asking for, and you and I did talk about this peripherally more than once. But so in addition to looking for the off-the-record stuff from the Boston Globe, the first interview with Gretchen Voss, which was the other Rule 17 motion that we couldn't hear yesterday because nobody put Boston Globe or Boston Magazine, I guess she works for, on notice. They have now made more Rule 17 motions last night that dropped. They want all of the outtakes from NBC 10 with regard to the with regard to the Dateline interview with Dennis Murphy. So that's NBC. So apparently she did that Dateline interview with Dennis Murphy. And that was, so they want the complete audio and video of all of the interviews with Karen Reed, including the unaired raw footage, handwritten notes, emails, texts, voicemails. Here's what I found interesting about this motion and the next motion, which is for the ABC Nightline and 2020 interviews with Matt Gutman. So they want same stuff there, the outtakes, the interviews, the voicemails, emails, text messages with any editors, anybody from the network that she spoke to. Here's what I found interesting is that these motions were already made. They were made before the first trial in October of 2023. And I just got to show this to you because, again, like, unless I have you here, like, talking me off the ledge, I feel like I'm sometimes like being completely gaslit and I need a little bit of validation. So let's just pull up one of them because both of the arguments are the same. But this goes back to, again, proper notice. So what happened was, this is the one that I just happened to pull up for the Dateline interview with Dennis Murphy. And what they're looking for here is conflicting statements because they're saying that, what she said on Dateline was different than what she said on 2020 and different from what she said to Gretchen Voss and different to what they'll argue Vanity Fair. They haven't made that motion yet. I don't think. We'll go through it. But so they want the handwritten notes, emails, text messages, voicemail messages. And they're saying that procedurally on September 1st of 2023, the Commonwealth filed this exact same motion, and they unsuccessfully sought to serve NBC Universal at its New York offices. So on October 11th of 2023, the court denied the Commonwealth's motion without prejudice, ruling that they must comply with, rules of service, right? Which they did not
Again, yeah,
But here, look at this. Here's the Uniform Act to secure the attendances. All right, wait. I have to redline this because I love my red pen, and I'm sure you love a good red pen too. Secure the attendance of witnesses from without a state.
My red
without a state. Just like, should it say from out of state?
Or without the state. I mean, it's
No, for out of state witnesses, right? Isn't that what this is about? Securing jurisdiction over out of state witnesses because they're serving them in New York. Oh, am I out of my mind?
No. I mean, when you want to secure the attendance of a witness from without the state, that would be the equivalent of a Massachusetts court saying, I want to haul someone in from New York. Obviously, a Massachusetts judge has no direct authority to compel someone in another state. And the usual process would be you would have to get a certificate, at least that's what we call it here, from the judge to issue in the out-of-state court. An out-of-state judge would then look at the certificate and say, I find good reason, bring the witness into the court from the other state and say, I'm directing you to go to Massachusetts.
Well, it's a long-arm jurisdictional issue, but I'm just worrying, I'm concerned the verbiage without a state from without of state or from out of state.
It's weird phraseology. Yes. I mean,
so I didn't know if it was a typo or if it was something that was,
I'm not sure what the official name of the statute is, but I mean, the bottom line is they're just trying to haul someone in from out of state.
So they already did this and they did it wrong the first time, but they never tried to correct it before the first trial. So now they're making the motion again before the second trial. And just another example of stuff they looked for the first time, they'd got it wrong. And now he's trying to correct it. And so here's the, what he's saying is a powerful example. The marked difference between the defendant's statements broadcast in the Dateline clip promoting its upcoming episode and the actual episode that was aired. And then they go into her statements in its promo clip. The network released the following confession. Karen Reed says, I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in his knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out, and in his drunkenness and in the cold, he didn't come to again? That would have been the moment. And then this would have been the moment you dropped him off at the party.
The problem here is this. If you're going to use italics and emphasize the key part, how about you emphasize the word could as part of that? I mean, let's be at least intellectually honest. She's speaking hypothetically. That's not an admission. I mean, you could argue it's incriminating in some way, because why would she say that? But if you're going to emphasize on the second page about how critical the statement is, you're burying the lead on the most important word, which is could, meaning I'm not admitting I did, but could I have?
Well, they're not going to emphasize that. I mean, right, exactly, right? And then this is a question, but they don't phrase it. This would have been the reporter saying this, but they included in what Karen Reed is saying here. This would have been the moment you dropped them off at the party.
Point. Could is an important word. And then after that, you really, in some way, could be, I mean, this is just sloppy writing, which, let's be honest, it's kind of been a habit lately with them. You should be emphasizing for the court that that's the reporter speaking. You don't want to give the court the possible misimpression of what's happening. And why would you italicize the question from the reporter and it almost reads as if they're trying to, no pun intended, saying it almost reads as if Karen said that and it's somehow important. That's just the reporter asking a question. I mean, there ought to be a question mark after that. He's not
yeah, or like here where they have Q. See, Q.
Right.
That's how you write it in script format or in transcript format. But they didn't do that.
This is just sloppy writing, which potentially could be misleading. I'm not saying he's trying. I mean, I have no opinion.
No.
But it's not, it's just all of the stuff that they're submitting. It just looks like it's thrown together. It's not, this has to be more careful.
Agreed. And proofread would be good. Just simply proofread by more than one person. If he's at his own office with his entire team, I don't understand why they don't catch this stuff.
Right.
So then the answer to that was, yeah, he would have had to have been. And then they're saying, well, this is conflicting with what she said on Dateline. Well, that was a Dateline clip. Then what she said on the Dateline episode, Karen says, I said, could I have hit him? Did I hit him? Question marks. Question, how could that have been? Karen Reed, I don't know what else could have been. I thought, did he somehow try to flag me down and maybe trip? And I ran over his foot and then he passed out drunk. I mean, I didn't think I hit him. So their argument here is they're entitled to all of her statements, admissions, and confessions. And then they go on to try and distinguish that from what she said to Dateline about she observed him enter the front door. And that conflicts with many of her other versions because maybe once she said side door. I mean, it seems to me like they're just grasping to find confessions.
Well, first of all, the use of the word confession there, I mean, they should say if there are any confessions. If they're trying to imply that any of that is a confession, they don't know what the definition of the word confession is. There's no confession there. Right. You can say that there are legal admissions, which only means they want to offer evidence against the defendant, her own words. And it doesn't even have to be incriminating per se. Legally, you would call that an admission. But if they're implying that these, dramatic inconsistencies, which newsflash, this is really kind of a nothing burger, really. If this is the evidence that you think is going to convict her, you put this in the full context of they're saying we need more time. I haven't watched the trial. You probably should watch the trial more and file these types of motions less, or at least prioritize them. I mean, whether they get this stuff after they asked for it before, I don't know that hypothetical questions of could I have hit him and this and that. I don't, there's an argument to say that shouldn't be admissible anyway under like classic, prejudice, probative value. They would call them federal court rule 403, meaning what probative value would it have if she's musing that I could have? It's not saying I did it. And the risk is that a jury, the DA is making their point by calling it a confession, that the prejudice that could attach overwhelms or outweighs in a legal sense whatever possible probative value the hypothetical musing aloud. Well, did I do this? Is that possible? Because I had no other explanation. I'm not even sure that would pass a balancing test under Rule 403. So to me, this is nothing. I mean, look, if you're going to do important things from their standpoint, I get it. The telematics thing is important. Maybe, but even that, you get an expert who kind of screws it up, and now you're going down rabbit holes saying all these inconsistent statements because a couple of words are different, and you're ignoring the fact that she posed it as a thinking aloud. Could I have done this as she's processing all this in a stressful time? I mean, they have a right to go after it. They have a right to try for it. But if this is what the compelling evidence is, yee.
Yeah, same thing with the ABC Matt Gutman interview. They want all of that stuff, and they say that in that interview, she said something different. She said, I pull at the front of the driveway. It's snowing. John has no coat on. It's windy, so I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone. And then they say, but. In the Gretchen Voss interview, she says, the defendant told Ms. Voss, so I pull right up to the front of the driveway. So I'm parallel to the house. John gets out the passenger side. John doesn't have a coat on. It's snowing, and he kind of half skips, runs up to the breezeway door, the area connecting the main house to the garage. And John opens the door and starts to cross the threshold, which they say is in direct contradiction of what she said before, which...
So we're splitting hairs over breaking the plane of either entering the house or not?
And then in Dateline, the question is, goes to the front door of the house? Yes. Did you see him go in the house? Yeah, I saw him approach the front door and put his hand on the door. So once she says front door, once she says side door, all three versions are incongruent with her newly released proclamations in Vanity Fair, which she says, or the person who wrote the article says, she wondered whether she had dropped her boyfriend off at the wrong house, and after a night of drinking, O'Keefe entered an aggressive stranger's home.
I mean, look, again, if that's the argument they want to make, and the house kind of has two front doors, really. I mean, it's kind of that I mean, it's not literally what you would call the front door, but I mean, it's also semantics. I mean, it's not like the reporter drilled down and said, well, there are 2 doors or 3 doors. Which one do you mean? I mean, she's just talking and says the front door. I mean, is this really what they're bringing in a skilled prosecutor to do, to, you know, split hairs over this? Now, you could also take another view, which is there is potentially a lesson to be learned here. When you have an open criminal case, you probably should not be doing interview after interview after interview and allowing the prosecutor to even try to parse out every semantic. And I think this is nonsense, if you ask me. But the fact that this is even being discussed is a fair question, because, you know, if they didn't have any of these statements, they wouldn't be even trying to make these arguments. But even putting that aside, you're going to have a lot better evidence than saying Karen Reed is a murderer because she lied about whether John O'Keefe went in the front door or the second front door 10 feet away, and whether he literally crossed the threshold of the open door or was just up there in the pitch black, as she's not literally paying attention. And even when she's speaking to this reporter, no one's asking her to clarify. I mean, this is a general thing. No one is saying, well, wait a minute, you know, there were 2 doors. So just to be clear, you saw him go in. I mean, the reporter's just letting her go. So I don't think this is going to be that big a deal one way or the other.
You know, but you're right. This is the risk that you run when you give multiple interviews prior to trial. This is also, you know, when you hear and you listen to, because I watch a lot of trials over here, a lot of jurors and general public love to hold the defendant's words against them. Love it. So you know that a lot of people who think that she's guilty are saying they're basing that on the fact that Jen McCabe and other perhaps first responders said, she said, I hit him. She confessed. That's it. End of story.
There's always another concern too when a defendant does this. And look, I don't think she said anything so terrible. It's not that. But here's the other thing. The risk here, of course, a jury is never supposed to draw any adverse inference in a defendant not asserting her Fifth Amendment right, unless that juror is Wendy Murphy, and then of course that means you're guilty, constitutional expert, scholar, and prosecutor that she was. But in the real world, sane jurors would not hold that and would be instructed by the court not to hold that against a defendant who's not testifying. And you hope that they do that. The risk here, though, is jurors, they wonder, they see things, and if they learn that you speak to the press again and again and again, but don't testify, why are you doing it the easy, controlled way, but why don't you do it this way? Now, they're not supposed to do that. They shouldn't do that. Do they do that? You don't know.
I think that, I mean, based on the trials that I've watched, I mean, I just watched a man in Delphi, Indiana, get convicted because he made confessions after being in solitary confinement for 6 months and injected with Haldol and, you know, held in prisoner of war like conditions. And, you know, apparently the jury found those confessions convincing. So,
well, the difference, I mean, that's problematic.
You never know what a jury's going to do. Right.
But I guess my point is, I don't think Karen Reed really said anything that interesting. That even if they are allowed to admit some of this and argue that these are inconsistencies, you know, I don't think this is, to me, this is much ado about nothing.
But you and I are very experienced legal minds. Mm-hmm. I think that the average juror who is not doing this day in, day out, could hang their hat on some things such as like that, inconsistencies. And it's ridiculous. And you and I think it's ridiculous because we do this every day.
True.
But I mean, you see what's going on out there. You see the way people think she's guilty because they say she confessed. And that's from a third party, you know, a couple of third parties who may or may not have close personal ties to, you know, other people who may have had something to do with this or be threatening. Who knows? So you and I can sit here and say that, but, you know, let's look to the chat to see if the chat thinks that people may hold these things against Karen, because without her testimony, there's nobody else to get up there and say, well, that's not what I really meant.
The only problem with relying on the chat, not that these are not smart.
You know what I mean?
I know
People.
a juror is going to get voir dired specifically on, if the client doesn't testify, are you going to follow the judge's whatever and not hold that against her? And they're going to be instructed at the end of the trial that you may not do that. And again, maybe I'm being idealistic and living in, fantasy land, but you would hope that you get jurors who are going to follow the law and the instructions, assuming they're not so convoluted that they don't know what the hell they're doing, which is another issue in this case, but that they follow the law and recognize that she has an absolute right not to testify and doesn't have to do it. But I mean, look, you obviously know the playbook of what the prosecution will want it to be, which is similar to what the civil lawyers against her. They basically made the civil version of this argument. Not that it was ever going to carry any weight. It was kind of a silly legal argument, but that was a public relations argument that she talks to the press. She's doing this. She's doing this. You ought to make her get deposed now. And all of a sudden the Fifth Amendment doesn't apply anymore because, she spoke to the media, which is a joke. That's not how constitutional rights work. But
they lost that motion.
Right, but they were making the argument. It was a public relations thing more than a serious legal argument.
Agreed, and that was in the civil case. The question is, will Judge Cannoni allow these alleged inconsistent statements to come in via reporters who could be called to testify because there's no privilege in Massachusetts? And are the jurors going to find them these?
I would expect
compelling.
If he at least entertains this and grants the subpoenas and they get the information, that at some point you would see an argument from the defense that, notwithstanding all of that, that at least as it relates to a lot of these statements about speaking in the hypothetical, I was thinking, oh my God, could I have done this? And because you can't cherry pick. I mean, if you're going to let in her words about the alleged accident, it's all going to come in. The other side has a right to complete the statement. And if it's all about, could I have done this? And I didn't know, and I couldn't think of another way. There's a pretty credible argument there. That's just too prejudicial because it's not a confession. It is qualified. So what possible probative value could a qualified statement have when considered against the risk that the jury might say, oh my God, there's the confession, when it's not?
And I would have made that same argument with regard to the inverted Sallyport video, like the prejudice part outweighs the probative value. But then again, look what happened. Everyone saw it.
Every state is different. I get it. That is absolute danger zone for a mistrial in New York about trying to introduce evidence of a video of that magnitude in the middle of a murder case. I mean, that is. I think the vast majority of judges actually would have granted dramatic sanctions and would have strongly considered all the way up to, dismissal of the indictment, and also would have given a tongue lashing to the prosecutor and said, you might want to call your carrier and consult counsel because this is going to go beyond this court for that kind of stunt.
I agree. And then we saw it happen in the Alec Baldwin case in New Mexico. That case was thrown out and that prosecutor put herself on the stand. Carrie Marcy, I don't know if you were aware of what happened. That was crazy.
That was
wild. That
was kabuki theater. That was, I want to testify. I want to be heard. That was
herself right on the stand and questioned herself. I mean, it was insane. I've never seen anything like it.
Public,
that judge dismissed it right there and then.
Having a public meltdown on live TV, not advisable. Yeah, that was bad.
It was excellent television, though. So then the they made these other motions that Hank Brennan said, "Oh, I don't know if you've seen them yet. I don't know if they were docketed." And I will tell you, from looking at the docket yesterday, they were not docketed yet. But here's what they were: they wanted a protective order for the internal affairs investigation. And I'm assuming this is against Proctor because it says it's still ongoing, but it doesn't say that it's Proctor anywhere in here.
The problem. Go ahead. I'll let you finish this, and then. Now, what this motion is right now that's on the screen.
Yeah. So that's this. So this is like a Rule 14 motion for a protective order. Yeah, and I believe they already turned it over. It might have been in that discovery dump that I went over, not last time, but the time before that, like number 49 or number 48.
Well, so all lawyerly again and underlying a trooper. So
Yes.
you know that they're done with Buchanan, but you're being told that Proctor is, and I know there was like a lot of online controversy over whether Proctor is toast or just hanging by a thread and soon to be toast. I mean, practically speaking, he's toast. It's just a matter of if he's fully burned yet or not. So are they talking about Tully here? I mean, if the theory is that Proctor is gone or is close to gone, or they know he's going to be gone, or is this another example? I hate to say it. Is this sloppy writing? Because it also, I mean, I hate to say it, but you underlined another thing to the attorney. Well, there's 3 attorneys,
Right?
you know. So again, this could just be another example of unclear writing. Sorry to say. I mean, I don't know what this means. I mean, my first question would be, who are we talking about? And now, is Tully considered a Massachusetts state trooper? I mean, he's got a
Yeah,
higher.
he's like a DL Tully, isn't he?
Right.
DL Tully, you know, because we read your letters, and that's how you refer to him.
Well, you know, he gets his rank until they take it from him. Like, for example, when Proctor gets fired, he will no longer be Trooper Proctor. He'll be Mr. Proctor. He doesn't earn that title when you're a disgraced, fired, misogynist, awful person. But you know, Tully, even if he got demoted recently, I don't believe he lost his rank. But they're referring to this person as a trooper. So maybe that does mean Proctor, because he's still, if he's not terminated yet, he would still have his rank. I mean, you know, Mr. Brennan didn't put the word disgraced in front of it, which would tip off who he's talking about. But I assume that's
Tully was rehomed. But then they refer to this June 26, 2024 Massachusetts State Police report concerning a pending internal affairs investigation. So that was prior to the mistrial. The mistrial was granted on July 1st.
Well, again, here we go. I mean, is this the wrong date?
We have to play detective here to try and figure this out. Why isn't he being more specific in this document? So he's asking the judge to protect something that the judge doesn't even know what it is.
It is hard to understand it.
The report references potential violations of Massachusetts state police policy. So
so it's against policy to, you know, call someone.
No. The report that they're trying to seal.
Right.
Yeah, I guess so.
I was making a joke. That is it against Massachusetts state police policy to refer to criminal defendants as whack job, other things.
C words. Yeah. Whack job, C words, or
kill them.
Or is the violation of the policy that he tried to reach out to the medical examiner to get her to change her findings?
Well, you know, it says it's ongoing, which, I mean, we're speaking in riddles and tongues here. I don't know what. Again,
this is like the Riddler. He's like now Hank Brennan has earned himself the title of the Riddler, and then look what she does. Allowed no opposition. Dates it yesterday. I don't recall her asking the defense if they even received a copy of this, no less whether or not they opposed it.
I don't know. I mean, I guess the motion itself is just saying that it go to the lawyers and not the public, essentially. So, I mean, I could understand why the lawyers might not care as long as they get the data and what it means. And of course, if it's helpful to them, they'll use it at the trial. But I mean, the motion was filed when? Yesterday?
Yesterday. The hearing was yesterday.
And there was no discussion about this on the record that I heard.
No. She signs it yesterday, allowed no opposition, and she sort of just dismissed everybody after they put their coats on and left. So, I mean, if you're going to allow it, you know, if you're going to allow it just sua sponte, then, you know, say that, but don't say no opposition, because you didn't give them a chance to oppose it, because it was just filed yesterday and you signed it yesterday.
What I can tell you is this, without getting into other cases and stuff. Proctor is, unfortunately for the Norfolk DA, is like a metastasizing cancer for them, in the sense that he has tentacles that spread in all of these cases, that his conduct could be at risk. I mean, in the Walsh case, obviously Karen's case, I don't know if he's involved in some of these other high profile ones there. I mean, he certainly is involved in a case I'm involved with. So let's just say it wouldn't be surprising if a lot of lawyers in a lot of different cases are getting that type of information, and it's just a normal thing that the whole office is doing, and that it's not a Karen Reed centric application. As just, we have to deal with a certain trooper across the board, and we're going to have to notify all the lawyers that have matters in which he's involved.
Hold please, because I have that. I love how you segue right into this, and you had no idea. This is all like cold, hard reactions from Mark Bederow, because he had no idea what I had to show him today, because he's busy and he has a day job. So here is something also filed yesterday. This is the Commonwealth's motion for a protective order with regard to Trooper Proctor's phone iCloud digital forensic device report. And this is a 4-page extraction of Proctor's work cell phone in the case of Julius Hammond Dacier. Okay, so it's not one of the other ones that we knew about, Brian Walsh, Ingolf Turk. This is now Julius Hammond Dacier. So they're saying they did an extraction of Proctor's cell phone, that there's a 4-page extraction report attached as an exhibit, which unfortunately I don't have the exhibit because it was probably, impounded. And when they say impounded, it makes me think like my car got towed in New York City and I have to go get it out of the lot. Like my car is impounded, or they put a boot on it.
I hate they use that word there. Just sealed and unsealed is so much cleaner. But but the rules there are very liberal to allow things to be what they keep calling impounded. You just ask for it, and it's basically, for all intents and purposes, done, as opposed to, other states, there are only certain specified statutory reasons which would allow something, because there is a presumption of openness. Court proceedings are presumed to be open, including the court file, to the public. So,
well, look at this, because this is now a cold read for me too. Since some of the redaction in the Hammond Dacier attachment removes references to defense counsel in the Reed case, counsel has removed the relevant redactions. So is he saying, I hate David Yannetti, I hate that man, while he's talking about this other defendant in another case?
I think it's safe to say, based on what you heard at trial, that there's a good chance that relates to David, who, by the way, if you know him, is a really nice person.
So nice.
Good lawyer, nice guy. And, Proctor has, he hates the whack job C, who he wishes would kill herself, hates the lawyer. Maybe it's not them, my guy. Maybe it's you. I don't know. You hate everyone. But that would appear to be referring to him. Just based on what we saw at the trial.
Yes, or maybe it's Jackson. I don't know. It's hard to say because, they don't give us a whole hell of a lot of information here. But again, this is allowed with no opposition. She signs off on it yesterday.
Interesting, too, for another reason. We're talking about work phones here.
Mm-hmm.
I believe the evidence at the trial, and someone's going to yell at me if I'm wrong, and please do. Didn't all the nasty stuff, wasn't that on his personal phone?
I think so.
So this is different.
I think so. Yeah. This says this is his work cell phone.
Now moving into, on his official, government phone, disparaging a lawyer on a case for which, he claims he has no bias. But, there he is saying, references. It doesn't say that.
It just says references. Yeah. It doesn't say disparaging comments.
We should be accurate. That's true. You could certainly reasonably believe that they're not, talking about inviting David to his, the Proctor family Christmas party. That's not likely, but we don't know what it is.
Or, Alan and David sending him a gift for, his crappy testimony or anything like that.
Probably not.
But at least in this one, they're restricting discovery of the report to the defendant, her attorneys, and personnel involved in preparing the defense, and prohibiting the dissemination outside of the criminal proceeding at this time. So I found that to be interesting.
Well, that's them saying we don't want this. We don't want to have a report in the media saying that Proctor is doing those things. That's all that means.
Oh no, I know. But here, this is also, I found this interesting too, because once I go down a rabbit hole, I'm all the way in it. So let's look at this, because this is kind of interesting. So this defendant, this Dacier, because I had never heard of him before. Have you?
No.
He was just sentenced actually last week
Oh, this case, the guy who just
on the 24th.
mall, that was crazy. Yeah.
Yeah. So this is and I wanted to show this video because look who's standing there right inside the courtroom as he's being brought in for his sentencing. Let's just, for fun, because here he is. Boo Ducky. And it's only 14 seconds. I'm not even sure what it shows, but I just thought that it was interesting that Buchanan was standing by the door in suit and tie.
Call the case, Your Honor.
I don't know. I mean, this is a terrible, terrible case of a guy who shot someone in broad daylight, killed him in the mall. The state police are investigating it. It's in Norfolk County, and Buchanan is there. I mean, I've had a lot of critical things to say about him, but I don't think seeing a murderer get sentenced and following it through.
No, but what I'm saying is he was just sentenced on the 24th of October. These
Right.
messages of Proctor, how recent are they?
Probably not recent. I'm assuming he hasn't had a work phone.
That's true.
Since when did he get sanctioned, or at least put on modified, what cops call be modified? I mean, that was right after the trial.
After the mistrial, right?
So, and also he was aware that the feds were on to him, months and months before that, because he knew it was like a matter of time. I'm going to get crushed at Karen Reed's trial. So I would assume, just by logic, there's that word again, logic. It's a big word, in the attic.
I know.
But using logic, that these messages had to have occurred months and months and months ago, before Proctor ever considered the possibility that I'm going to get screwed. And when he was in the prime or his salad days of, speaking the way that he was speaking, which would also lead you to believe the messages are probably not favorable and nice.
Agreed. So he was just found guilty, this guy Hammond Dacier, on October 22nd of first-degree murder for killing Dejune Beasley, and that murder was on January 22nd of 2022. Okay, so that would have been 1 week before Officer John O'Keefe was murdered.
Right.
And then he was sentenced to life in prison with the possibility of parole after 30 years and this was Judge Krupp in Norfolk County. So, I mean, I just thought it was interesting because it was a case that I hadn't heard of. And,
I didn't know my name. I very much remember, the South Shore Plaza, because that's crazy. I mean, that's just shocking beyond belief. And it was broad daylight on a weekend in a very large mall. If you know that area.
I don't, but Good Citizen said that her daughter was at the mall that day. That is really horrible.
I had a summer job at that mall 100 years ago for a couple of months. Yeah, when I was.
What store did you work at?
Do you remember the Warner Brothers studio store they don't exist anymore, but like way back.
They would sell merch and stuff. It was kind of like a Disney store, but for Warner Brothers type movies and stuff.
Yeah, and they also had like a section where they sold like prints, like nice, like I forget what you call them, like lithographs or whatever. Whatever. It was just like one of those things that was like a cool concept, I think, in the early 1990s, and disappeared.
My first job I was the counter girl at Howard Johnson's.
Well, there you go.
I was the counter girl at Howard Johnson's.
God, not that one.
Which one?
Not in Times Square on 45th Street.
No, on Long Island. It was on Long Island. But I scooping ice cream and doing all that stuff in the orange polyester dress, the whole thing. And Mark Gastineau used to come in for ice cream when he was with Brigitte Nielsen. Do you remember?
Of course.
Together? And it was like, my little brush with greatness as a 16-year-old, scooping ice cream at Howard Johnson's. It was kind of fun. They also moved for a protective order of Trooper Proctor's text messages in this case. Wait, or no, it says which may be evidence in an unrelated pending criminal case.
Well, this is fair.
It is Karen Reed. It says Karen Reed.
Right, but they're saying that his phone may have confidential case information related to other cases. I mean, they
want to redact the information of minors and unrelated. That's pro forma. Yeah, and they're saying they provided Proctor's testimony, which ended in a mistrial, blah, 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 blah. They're providing an official transcript of Proctor's June 10th and June 12th testimony in the Reed matter.
Every lawyer is getting that.
Oh, and here. Trooper's testimony in Reed included references to prior testimony and text messages obtained as part of a separate federal proceeding. The parties in Reed received those documents in response to a TUI request for discovery. The records were only disseminated to the parties in the Reed matter pursuant to a February 20, 2024 federal court order restricting the recipients from disclosing or disseminating those materials. And then it says on September 24th, 24, Commonwealth received outside of that court order certain partially redacted text messages referenced at trial in the Reed matter. However, those chains contain full participant phone numbers and images of minor relatives of a deceased victim and unrelated Facebook friends. Non-parties have a privacy interest. Okay, I mean, I agree with that. Some participants in the text chains have been subject to harassment and have a security interest in not having their personal identifying information released.
So what they're saying is, I mean, I believe they're talking about the children that John O'Keefe was taking care of, and some participants in the text chains have been subject to harassment is their way of saying, obviously, Proctor was communicating with the McCabe's and Alberts and those people, which I'm not sure if that came out of trial or not, but I mean, they're saying they're being harassed. Isn't that what they mean?
That's who I'm sure they're talking about.
I mean, it's participants plural. So
in the text chains, but in Proctor's text chains. So Proctor was communicating directly with, well, yeah, we know he was actually with Jennifer McCabe and
that's what it sounds like. I mean,
other witnesses.
That's what
the feds found. That's what the feds turned over.
Mhm.
And I don't know if you saw Microdot's latest video from yesterday, but
that was a good one.
Amazing, right?
Yeah,
because all of that stuff, I'm trying to remember because I
didn't watch all those hearings in real time, and I wish I did. I mean, just wasn't that interested in this and had no need to. But it would have been even more appalling to see what was going on, in live time. But the idea that prosecutor, I remember talking about this, but seeing the video makes it worse, that she could get up there with a straight face and say that, we've reviewed these documents and they are in essence corroborative of our case. When you're talking about the Proctor stuff, the ARCA stuff, and all that other stuff, and say that that's not exculpatory, if that is a prosecutor's true understanding of what they believe exculpatory is or isn't, then the scandal in Norfolk County is a lot worse than you think, because that is just an asinine representation to make, and to belittle the defense and talk about, these BS arguments about relationships between Proctor and some of the other people in the case. And then it turns out there's a ton of it coming from the feds. That was a really bad look for that office. Terrible. And of course, with Morrissey's press conference and all that stuff, that probably was the most damaging video just about the credibility of the prosecution itself, as opposed to some of the other ones, just about how there's so many problems with the actual evidence, which point away from her.
Well, I remember we went over that hearing. I went over that hearing with a lot of the viewers here that are in the chat, and you guys remember that. And we watched Ms. McLaughlin, as they call her, Ms. McLaughlin get up. And I remember when the TUI stuff dropped, and then there was like a weekend, and she's like, "Oh, well, I looked at everything, and all of it." And she looked at 3,000. It was 3,074 pages, and I know that because that was the title of my thumbnail. And she's saying it's already stuff that we already have.
Well,
and that was. I couldn't believe that she has never spoken a word. And Microdot pointed all that out beautifully. Excellent work, by the way.
The problem with what she said is, number one, if you take the part of her statement as true where she said, "I looked at everything," then you can't believe that she says virtually none of this is exculpatory, because even by something being arguably exculpatory, whether you agree with it or not, the ARCA evidence is as exculpatory gets. I mean, it says that it's our opinion that the injuries of John O'Keefe are not consistent with the car and vice versa. And that's about the end of the case, if you believe that. So clearly that was exculpatory. So if she read everything and was implying that that's not exculpatory, well, that's not true. If you didn't read everything, well, you just said you did. And then if you don't think the portions of the Proctor text about, intimidating the medical examiner, the gifts, the just misogynist part of it, don't worry about Brian Albert.
Tell them the guy never went in the house.
All that, and which also raises, if she thinks she's telling the truth, then she has a fundamental lack of understanding about what exculpatory means. Because if nothing else, if you've read all the 87 letters I feel like I've written in the last couple of months, impeachment material, under Giglio versus United States is just a different type of Brady material. It's the same thing. It's exculpatory if it discredits a witness. And anybody who doesn't think that all that Proctor stuff is not favorable impeachment material of him, my God, so that was a terrible look for the DA's office, that 30-minute video that he released. That's devastating.
I want to know who does the voiceover for him, because I love
yeah, the serious
British accent. I love it.
British, I think, right?
I don't know. Is it Rich? I haven't met him. So I don't know if he's British.
But whoever
does the voiceover is amazing.
Great, yeah.
And just shout out to Morrissey's iCloud for the screen name, the handle. Excellent work, Morrissey's iCloud. Says Microdots perfection always. Yeah. So again, she allowed that with no opposition. But again, we don't know if any opposition was voiced because it wasn't brought out yesterday. They were never even given the opportunity to oppose it, as far as I remember. If anybody in the chat knows differently, by all means, you can point that out to me. Here's something else I wanted to talk to you about. The bite expert. So now they have a dog bite expert, this James Crosby, that they've exchanged his CV, and they're going to ask that he be allowed to testify at trial. And this is interesting. So let's just take a little look at this. And we'll pull up his
they make an offer proof on what he would be testifying about. Is he going to say that these are not consistent with dog bites? Is that going to be?
You know what? I think that they just exchanged his CV, but I'm going to have to go back and look at it again. But I will do that while we're watching a little video that I have for us. But anyway, here's his LinkedIn profile. So we have a little idea of what he does, and what his qualifications are. Here he is with a dog.
Well, it's a good-looking dog.
He's a certified behavior consultant -canine consultant and writer out of Jacksonville, Florida.
I'm already troubled by this, but let's.
Right. So here are his specialties: dog training, aggressive dog evaluation and rehabilitation, dangerous dog issue expert, fatal dog attack investigator and expert, legislative consultant on animal control, and dangerous dog issues.
Well, he sounds like a dog trainer, and I don't mean that disparagingly. I mean, he sounds like a behaviorist. And the issue here, presumably, is whether an expert on either side, whatever side you are, has the expertise necessary and credentials to look at photos of John O'Keefe's arm and give an expert opinion on whether those injuries appear to a degree of medical certainty to be consistent or not with dog bites or scratches. And ironically, what you saw yesterday, I think you saw Brennan argue with Dr. Russell that she's got the wrong skill set. When she, by my recollection, although she's not a veterinarian, she was an expert in actually treating people medically who had dog bites. And correct me if I'm wrong, literally wrote the book on dog bite injuries. That's what you call a credentialed expert, whether you think she's too old and had been retired and so she was out of practice, whatever, different issue, which I don't think she was. I thought she was actually quite effective.
Right. Or because she reached out to them, somehow she's unqualified.
Whatever, yeah.
She's a medical doctor. This guy, they call him doctor, but he's got a PhD.
Right. So, but the irony is, this is the kind of witness that I think the defense would very aggressively want a Daubert hearing to try to keep from testifying for lacking the credentials of an expert in the field. He may very well be an expert in dog training, behavioral analysis, or the, what dogs do and when they're rabid and all that kind of stuff. But that doesn't translate to, I'm looking at medical photos, and based upon what I see, that to me looks like dog bites or not. So, I mean, it's just ironic to me that we're having a hearing and hauling Dr. Russell back when she's already testified once. And it appears that the prosecution is going to try to have an expert who is not a medical professional, whether it be human or canine, and is, unless he's going to testify about the behavior of a dog, which I don't think would be wise, because we're talking about a German Shepherd, half police dog, with a documented history of biting and attacking.
Hold, please. Hold, please, because here's an interview that he did a year ago. Listen up, everyone, because I think he could be actually very helpful for the defense.
Label it as an XL bully attack, and claims assert that one of the...
I would speed it up, except for that she's talked so fast that let's hear her interview him a little bit, where you just listen to the little things that he has to say.
500 cases in your research as an XL bully attack, or can more be done to prevent these attacks? Now, I note actually,
and also it's important to note this is not a fatal dog bite. Nobody's claiming that John O'Keefe died from dog bites.
Oh, but she's also saying about preventing attacks. That's behavioral.
Right.
That's
so listen to what he's got to say.
it's a great honor today to speak to Dr. Jim Crosby, who is a retired police lieutenant inspector and also a dangerous dog expert who has personally investigated more fatal dog attacks on humans than anyone else in the world. Now, welcome, Jim.
Thank you. It's wonderful to be here, Dame Andrea Jenkins, and I'm honored to be speaking with a member of Parliament.
Thank you, Jim. Please call me Andrea. Now, following the recent dog attacks and the Prime Minister's announcements on XL bullies, I thought it's best to speak to an expert on dog bites like yourself, Jim, and find out really, is it to do with the breed of dog that causes these bites and attacks, or can more be done to prevent these attacks? Now, I note actually, Dr. Jim, that you've researched heavily into the recent attacks and believe that it's not as simple as to label it as an XL bully attack, and claims assert that one of the two dogs that killed was not on, Ian Price was not on XL bully. So deep digging obviously is required. And I understand, Jim, that you've researched over 500 cases in your research across in the US.
Yes, during my research for my PhD, I've examined over 500 US cases and kept an eye on Canada and Australia and the UK. And I've personally attended nearly 40 human fatality cases on scene with law enforcement as a retired police officer, but bringing my skills and knowledge in fatal dog attacks to these investigations, and actually been present at the autopsies of the victims and in the crime scene, looking at the physical evidence, gathering the behavioral evidence, because I've laid hands on now nearly 60 dogs that have killed humans after the attack, looking for causes and contributions.
Wow. I mean, it must have been pretty gruesome, but I guess you're made of strong stuff, Dr. Jim, having been in the police force. Now, I also understand, before I go on to some questions with you, but I also understand that you handled a lot of dogs in your police force career as well.
Oh, yeah.
If you want me to pause it at any time, just say.
This was not only during my police career. I was never assigned as a canine handler, but I worked alongside them. But since then, I have run 2 animal control or animal services agencies in the US, both of which we took in thousands of dogs. And I've worked with probably thousands of aggression and problem behavior cases, again, across the United States. I've actually been involved in two, one very serious and one fatal attack here in the UK. I was actually taken to the scene by the federal police in Australia, pulled off my airplane to assist them there. So I've worked these kinds of cases literally around the world.
I mean, it's honestly, it's a great pleasure to have you on today. And it's so important that, you know, that we actually, if we're making some decisions with this as a government, that it's backed up with research as well.
Yes,
so
absolutely.
I've got 5 questions for you, Jim. Now, people often say, what if a child is involved? I mean, as a parent myself of the 6-year-old, you know, it's every parent's, you know, one of our greatest fears. What about if a child was attacked? When talking about dog attacks regarding fatalities, is there a typical victim profile regarding dog attacks?
That's one of the surprising things that my research in the US discovered. We always think that little children are being killed and victimized, and there are plenty of them, but the median victim in the United States of a fatal dog attack is a woman in her 30s on her own property with a dog that she either owns or is sheltering, and is usually dealing with multiple dogs by herself. Now, the next category down is 2-year-old male children, not little girls. For some reason, 2-year-old little boys are the next victim category. And then it goes down from there. But that's one of the interesting demographics that I've been able to research, and I'm going to continue, including such things as socioeconomic status. The median victim in the United States lives in a neighborhood where the household income is more than $100,000 a year.
Wow.
So this is not something that's happening in bad neighborhoods to horrible people. It's things that are happening someplace like just outside my window here, Richmond. Very nice little town.
What?
What the hell is he talking about? I don't.
That it's not just poor people that have pit bulls that to guard their homes that are getting mauled by dogs, but it gets better.
Does he have an
opinion? He talks about the breeds and when a dog would attack. So, I mean, this is all like, okay, call him. Hold on, listen.
Here. So this is something that is in our own backyards.
I mean, it's to hear, you know, the demographic as you speak of then. What do you think the correlation is then, you know, with a woman sort of like my age to a boy who's 2? So do we understand why in the research, why it tends to be those 2 profiles?
Not yet. I'm continuing my research, and I've actually been offered an appointment as a research associate at Harvard University in the US. And we're going to be looking into more of those identifiers and the circumstances. But that's the problem we've had in the US, as you do here. We don't know enough.
Yes.
If a story comes out, it's an XL bully that mauled a child. Well, there was stuff that happened before the incident, during and after the incident that applies. And we need to dig deep and to really look at these cases and find out if, as we found out in the US, what we think is happening wasn't necessarily what was happening.
Right. Thank you. Now, are there common threads or trends which occur during serious and fatal dog bites cases, which can be spotted in your research so far?
Yes. Most often we find that the humans involved, the caretaker or owner of the dog, has either ignored behavioral warnings before the incident or has encouraged bad behavior in some way leading up to the incident. For instance, you have a tough walking down the street that wants to be perceived as a true bad guy. That person may be instigating his dog to bark and lunge at others. And then if the dog gets loose by itself, it has learned a default behavior to show an aggressive display or threatening behavior towards anyone not his owner. And I think that has a lot to do with the behaviors we see. These are dogs that are being set up to fail, no matter what kind they are.
So
So Vanity Fair reporter found and sought out a woman who had been attacked by Chloe, or her dog was attacked by Chloe. Now I can't remember, in 2018, and interviewed her. So isn't it true, Mr. Crosby, because I'm not calling him doctor, that Chloe had previously attacked someone in 2018? And so what you're saying is because Chloe had a prior attack, that would make Chloe more prone to biting someone else in the future.
Yeah, I'm just, that's all true. But I'm still kind of scratching my head saying, what is he going to say about, medically speaking, why those injuries are or are not? Is he just going to say, because I've seen a few dog attacks, not several hundred or whatever, and it doesn't look like that? Is he going to discount the whatever, when a medical doctor who wrote the book specifically on dog bites and this and that, and has been in the ERs, he also seems to be talking a lot more about fatalities where somebody's getting mauled.
Right.
John O'Keefe, God bless him for what he went through. Even if that was a dog attack, which many people believe, I mean, that's clearly not the principal, that's
injury. Not the cause of death.
Right. But to me, I'm just laughing in my head anyway, because in watching the video yesterday, you heard Brennan say, Russell doesn't have the right expertise. So we need to have a hearing, and we're going to, we have confidence we're going to move to strike her. She doesn't know anything or know enough or have relevant testimony to offer or expertise about dog bites, when she's a ER retired medical doctor who literally wrote the book about, dog bites and injuries. So we're going to call a PhD who has no medical training, who is a behaviorist, and everything he's talking about here, and he may be very good at it, I'm sure he is. He's talking about dog behaviors and demographics and socioeconomic status of people who may be subjected to dog bites that are fatal. It doesn't make any sense. And even when he sees dog bites, if he's going to fatalities, he's not looking at scratches and whatever. He's looking at gaping holes and mauled arms and legs that people that are, you even want to think about what would happen that would result in like a pit bull mauling a child to death.
Right.
It's horrible. That's not what this is. I can't see unless we're missing something.
Let's let it play a little bit longer. But like also, it seems to me that he also, after these fatalities, has something to do with the dog. He examines the dog, right? So has he found Chloe? Has he examined Chloe? These are my questions.
Well, that's a really good point, because if he's allowed to testify and attacking his expertise, the door will be wide open to another line of questioning, which is a hell of a lot more interesting than his opinion on what caused the injuries, or in his view, didn't cause them, which is, as a behaviorist and all of this, it's important to know the dog, if you will.
Right.
And, not to misquote from the first trial, but, what, if any, steps did you take to locate the dog? What did you learn? Did you look at all these records? Did you learn where the dog was? Did you try to contact the new owner? Did you see if the dog is still a biter? Did you learn whether, when it was the Albert family dog, whether, they were walking down the street like tough guys, like he was describing? What is the net gain that the prosecutor gets from this?
How about try and prove that the injuries were caused by a car accident? Not try and disprove that his arm was attacked by a dog. If that's the theory that you're going with, the theory was the dog had nothing to do with this. That's the theory. But now you're going to have an expert come in to testify that the dog had nothing to do with this. It makes no sense.
I go back to the ARCA comparison and what we talked about earlier, how a lot of people, at least online in the Twitter quarters, who don't understand burdens of proof and what happens. And it's not good enough for the prosecution to have a battle of experts and say, well, maybe they cancel each other out. In other words, that the defense expert could be right. If the defense expert could be right, then that's going to favor reasonable doubt, whether it's related to the ARCA stuff, dog bites, or whatever. So whether, if you assume hypothetically they don't knock out Dr. Russell, and I don't know how they could, to be honest, but if it's her or somebody else who is a medical expert and is going to give you true expert medical testimony, or they find a veterinarian or whoever, How is the DA going to not just cancel out Dr. Russell, but annihilate her so that she's not worthy of belief, she's not credible, by having, no disrespect to this guy, he's probably very good at what he does, but a PhD behaviorist talk about an outgun, a medical doctor who looked at all these in the ER and wrote a book about it. I mean, what are we doing here?
And hadn't she also been present at like thousands of autopsies? Like, I can't remember her, and I didn't have time to go back and watch her pedigree, but
biggest knock you had it, and I'm not saying it's a knock, but if you were going to attack her, by my recollection, the biggest thing was that, she wasn't practicing anymore. She's retired. And if you want to complain that she somehow, immersed herself into the case by seeing a news report and saying, oh my God, that's not any less impressive than hiring, putting out RFPs on the internet to get cell phone experts, which is essentially what the DA did and what they appear to be doing with other experts that they want to use in this case. So I don't know what they're doing, and I don't know. I mean, maybe he does have the experience. We're not seeing it in this interview, but
well, there's a little bit more. So let's let it go a little bit. Hold on.
So delving a little bit deeper there, Jim, back to what you said at the beginning, a woman typically of my age well, I'm a lot older than 30 now, to a 2-year-old boy. I mean, clearly, a 2-year-old boy is not going to be like trying to set up that dog to be aggressive. In those instances, in your experience, what do you feel could be the reason that the dog attacks?
The biggest issue with children is parental supervision.
Okay.
I don't care what kind or how sweet or how long you've had the dog. Don't leave your children on super and funny coat and gestures, because the message that we wonder, and we're digging in, why is it little boys? Perhaps boys are not be as comfortable or might be getting older and have met.
So really what you're saying so far, really, it's about the responsibility of the owner, not only protecting their children, which I have to agree with that as somebody who's got a child myself. I'm constantly looking for any danger spots that we, to protect him. And with those, and I just lost the thought, but it's not necessarily the behavior that is exhibited was originally focused at that class of victim. The woman may not be killed because the dog was taught or encouraged to be aggressive towards a woman, but because it has these default behaviors that it then transfers to an unintended target. Yes. But in your experience, Jim, is there any typical breeds of concern when it comes to dog attacks, or a particular breed amongst the most severe attacks that you've come across?
Well, I can say that the most innately vicious and nasty breed is the one with 2 legs walking around on the street and catching the tube to go to work. As far as dogs, large dogs tend to make large holes.
Yes.
Dogs bite when that behavior makes sense to the dog. Bites are not, every once in a while we have a mentally ill dog like the serial killers we have in the US. But probably 99% of the time the bite makes sense to the dog. So we have to, that's part.
Right, like the dog is protecting its owner.
Part of the investigation is figuring out why and how that made sense. As far as breeds, big dogs make big holes, little dogs make little holes. People are killed by everything from Great Danes and XL bullies, whatever those may be, to fatalities by a Papillon and Dachshunds in the US. Right. Small dogs have killed people too. Right. It just takes more work.
Of course. Thank you, Jim. So what are your suggestions then, based on your research, for reducing the most serious bites and dog attacks, please?
The biggest suggestion and recommendation is that we look very deeply into everything from where the dog came from to how it was raised, how it was disciplined, because, for instance, aversive training methods are proven to cause behavioral issues down the road.
There has been some speculation that Chloe was a washout police dog, that she was a canine failure, which is a washout.
Want to look at the family situation. What was the dynamic between the humans? Was there emotional upset at the time the bite or bites happened?
Was there a physical altercation, like a fight happening, right?
Want to look at the individual dogs. What makes that dog tick? And again, what made that behavior make sense to that dog at that moment? And then also look at the community and what behaviors and what actions are being tolerated by the community around. And my goal, and I've been fortunate enough with my police background and so forth, to be able to send people to prison in the United States for their dogs taking lives or mauling people and seriously injuring them. But we need to hold the humans responsible. My understanding is that, yes, you have the...
So under his rationale, if Chloe mauled doggies, then the Alberts should go to jail.
Well,
those are XL bullies here.
Thing, because when the Alberts all testified about the dog, which is an interesting way to phrase your pet.
Not good with strangers, right?
But there was an emotional detachment. I mean, I'm a dog person. Everybody knows it. Every now and then I'll pick her up and put her on the screen, and my other dog, who doesn't really come in this part of the house. But if I'm the defense, I want dog owners on the jury, because dog owners are gonna just say, you're not getting me to voluntarily, I don't care what my dog did, you're not getting me to voluntarily just get rid of my dog or dogs without grabbing it from me and beating me up and taking those girls away from me as I go down swinging, no matter what. And they didn't really seem to care one way or the other. It was, it was unfortunate. And I think jurors would be, who are pet owners in particular, but dogs specifically, would really be troubled by that and say there is a detachment there that makes you feel like that it's not so much that it's just a dog, it's evidence. And we got to get rid of the evidence.
They referred to Chloe as it more than once, it. And I have another question. Was Chloe microchipped?
If she was, they would know where she is or was until the microchip went, no longer chips.
Can't that be investigated somehow?
Well, yeah. I listen, what's interesting is this. In Massachusetts, anytime you want to subpoena anyone who's not a party, you have to get all this permission, all this Rule 17 stuff. As you know, in New York, you just start blasting, and every now and then you may have to go to the judge with an affirmation explaining why. And of course, if you can articulate a good faith reason and 99% of the time you'd figure it out. Chloe must have had a vet in the Canton area, right? How hard can it be to track all this down? And if Chloe had a vet, then you would know the answer to your question. Was she microchipped or not? That's going to be.
What does a microchip show? Somebody said it's a chip, not a GPS. But what does a microchip show? Like if somebody finds a pet, then you know who owns it. Is it? I don't know what a microchip exactly does, because I don't.
Identifying information, and obviously you have to take it to a vet to find the chip and all that, but it's identifying. So it's not just some random stray dog. So if you
they're
find
not tracked,
a dog, they'll have your information and all of that. But there's just all kinds of things that you could see about the dog that you would think the owners should have known or demonstrated a little more disturbance that we had to get rid of our dog.
Then he goes on to talk about his classes that he sells. So, there's that, and about how people should have dog licenses. But again, where's the added value here? Why are we not trying to prove that the injuries came from a car instead of trying to, again, be on the defensive and prove that a dog didn't do this? And how could he even say that without having examined and or met the dog? I'm so confused.
I'm assuming that they would have this guy lined up to be a rebuttal witness. Obviously, if they kept Dr. Russell out, I don't think they would introduce this. I think this is purely to rebut defense evidence if it comes in, but it doesn't seem particularly powerful. It doesn't seem, once again, to be, at least based on this interview and the resume, to be the right guy for this skill. He seems actually pretty smart about his field, but the issue here is a medical opinion and explanation about whether those injuries are consistent with dog bites or scratches, not about the socio-demographics of someone who may get bitten by a dog.
I'm confused. I have no idea why they would call him.
I don't understand this at all.
Sebastian. Thanks, Sebastian, for the 20. What would happen if the SJC rules that Aunt Bev must poll the jury from the mistrial while the second trial is going on? Can she delay the poll because of the second trial? Or if the poll jury says not guilty, then what?
So that's not how we do it here.
Right.
We're not going to have balancing trials and that would violate the whole double jeopardy thing if you had already started a second trial. So there is no second trial at all until this issue is resolved in advance. And if the SJC takes time and makes January untenable, then there is no trial, whatever the judge wants to do. If the SJC says we're not ready to rule till April, I'm not suggesting that would ever be the case, then there's no trial, and that's that. So nothing is happening, notwithstanding what Judge Canone says, until the issue of double jeopardy is resolved. You can't start a second trial and put her in jeopardy while she may already have a right to be free from double jeopardy. So,
right. So that has to be resolved before the trial even starts, which is why I think she's going to grant the continuance. She's going to have to, because she can't force the SJC to rule on her schedule, despite the fact that she can force people to take red eyes and other things. And in fact, David Yannetti said he had a conflict one day because he had a trial or something in another court. And she said, well, you just tell them to call me and I'll get you out of it, because it was district court and she's superior court.
Yeah, I think that is a large part of it, in all fairness, that she did want to know what court it was. And it is a quote unquote lower court murder case, high profile versus, misdemeanor in the town court. You're coming to see me. That's not that rare. I mean, we've all dealt with that.
Right. Part of me also felt like she thought she was going to catch him in a lie when she started. What court is it? And because he was because Jackson had already made a stink about, not a stink, but just said, I couldn't make it on this day. And I think he was, I can't make it on that day either. And so I felt like David was like, oh, I have something. What court, it was kind of, it just, I don't know. It just kind of rubbed me the wrong way, but.
It was odd.
Why does Morrissey not handle it? The DAs don't do that. I don't know that he tries cases. People have said that he's never tried a case, so you can opine on that.
I mean, it's usual that the elected official, certainly in larger DA's office, is not really anything more than a politician and decision maker, shot caller. Robert Morgenthau in the Manhattan DA's office and the U.S. Attorney's office for 100 years. He never tried a case. He was an intellectual, very experienced figurehead and understood policy and had common sense and discretion, but he was not a trial lawyer. Morrissey, I think the larger concern is that his career trajectory before he became DA is just political hack, not even as a lawyer per se, but just, the guy's had a job on the public dollar for the better part of 40 years, right? I don't think he's worked in the private sector in all these years, and he had a soft landing to be, DA for life or not. We'll see in a couple of years in Norfolk County. So it's never good when somebody is a career politician and then they land as their final settling in for life job as DA. I mean, that to me is just a recipe for disaster. And take a look at what's going on in that county. None of it's surprising.
Edward says, yes, with Lally, he definitely said he was the guy driving and Proctor was at the rear tail light. On Cross, he switched to maybe tow truck driver was driving and he wasn't sure who was the guy near the rear tail light.
That's right. He definitely.
We're talking about Yuri now.
Back. You'll have to wait and see how it plays out. I mean, the record is the record, and he's going to be confronted with this at the second trial. But he was quite certain and confident about who he and Proctor were when it really didn't matter. But when the video was exposed for what it was, he got very uncertain. So that's troubling.
Absolutely. Shannon, thanks for the 5. Yuri also said he didn't know why it was inverted. That's just the way it was given to him by the Canton PD, but they were supposed to be recused. Oh, yeah. Canton PD was supposed to be recused because of the conflict. So that was kind of weird, too.
Is terrible. And of course, you could go as far back as you want. But the real question is, well, why did you get it in the middle of the trial? When was it even sought? How long did you know about it? All this kind of stuff. And I mean, what happened with the inverted video is a disgrace and embarrassment. And any prosecutor, how they didn't get sanctioned for that. And we'll see how it comes out in the second trial. But that was potentially unethical. I would be very concerned if I was Lally about possible exposure for that. When did he know about this? He must have known beforehand. I even recall him asking questions about where the driveway was on the left or the right side, outside. How does that not trigger you to say, well, wait a minute, this is not the video. Why, even if you knew it was inverted and you were going to use it, any ethical prosecutor would have brought out on direct, to the extent you were going to even introduce this kind of garbage evidence, you would at least bring out and be transparent and honest that this video, just so the jury knows, is inverted, and this is why, this is what it means, and I'm only showing this to you to give you something. He didn't do that. He tried to sneak a fastball, on the inside corner, and, it didn't work. And they're going to get screwed for this at a retrial, because also, someone like Alan Jackson's going to have a lot of time now to think about this. This was all on the fly the first time.
Mm-hmm.
Didn't have much time to really flesh this out. They're going to get answers about this, and I would assume they're going to make a lot of hay with this.
I'm trying to pull up that thing because I don't know why part of this is not showing up. They exchanged the engagement letter, so like the retainer agreement, the engagement letter with James Crosby. That was 4 pages. And for some reason, the rest of this document is not.
What's the date of the engagement letter?
It doesn't say, because it's not. We didn't get the attachments.
Right.
Thank you, Sarah, for gifting 10 memberships. You're amazing. Thank you so very much for that. Girl Ryan looked it up and said, from Massachusetts, the site is the attendance of witnesses outside of state, right? Not without a state. Thank you for proving me not crazy. I appreciate that. Letteros by Bederow says, Mark, your letters have changed lives. Wow, that's a lot of pressure, Mark, huh? That's a lot of pressure.
Letters write themselves. Circumstances dictate. It's, it would, well, no, my God.
Here, Greg says, can we replace Matt Gates with Mark Bederow for Attorney General, please? Thanks,
we should refund Greg his $10. That's no. At least the second part of that, no. But
good citizen, did you all notice that Brennan was calling the DA the government versus the Commonwealth? Yeah, but he was actually calling the defense the government at one point too. So.
He flipped which side he was referring to, and he referred to the DA or Commonwealth as the government, which again, we're nitpicking. It doesn't matter, but most lawyers would never call the state prosecutor the government. It's just one of those things. Like in federal court, it's the government, which is the U.S. attorney.
Yeah, and he just, understandably, it was his first day as a prosecutor.
At least in a long time. I mean, he used to be a prosecutor, but it's hard to program your brain back. But that, again, goes back to the whole just absurdity of all of this. I mean, no one has ever answered the question, why is he here? I mean, it's the fundamental philosophical question. Nobody doubts his skill. He's a credible, accomplished lawyer, but why the hell is he doing this? And why did Morrissey arrange for this? And why is Lally sitting next to him? I mean, this is crazy town.
We're back in the upside down. Cindy, thanks to the 5 jurors, didn't follow instructions. They didn't believe either side's theory and were speculating. And that is the definition of reasonable doubt.
That should be an acquittal if that's what they're doing. Yeah.
3 wizards for some light reading. Another heinous case where the murder took place in Canton. An officer from Dedham was involved in the kidnapping. Happened in 2014. Google James Robertson. Do you know about that case? Because I do not.
I think I do, but I'm not certain.
Thank you.
And there's an interesting backstory, but I'm not sure it's the right case. So I don't want to tell that story, but I will make sure it's what I think it is. And then the next time we talk, revisit that if it is, because you'll get a chuckle out of it. Not the fact, terrible facts, but there's it's the whole small world component that I think is the case, but I'm not sure.
So, but going back to the exchange, the Commonwealth exchange with regard to James Crosby, the dog expert that we just talked about, what they exchanged, they didn't say even anything about his testimony. They exchanged a copy of his 11-page CV, a copy of the list of materials that they sent him to review, which is 1 page, and the copy of the engagement letters that were 4 pages. So it doesn't say we intend to call him as an expert, what he's intended to testify about. There's no summary of testimony. It's just a basic
the behavior
discovery dump.
It has to be for the medical stuff, even though he's a PhD, because the dog's behavior is not relevant. I mean, the prosecution's position is there's no dog bites, so it didn't happen. Number one. Number two, why would they call an expert to talk about a dog's behavior when the dog has a history of biting and attacking? That's not helpful for that. So this has to be their expert to rebut a medical doctor about what those injuries could be. And it's, I mean, we'd have to hear what this guy has to say, but it seems odd.
I can't see what the value in calling him would be, because he's just gonna, on cross-examination, I would kill this guy into admitting all kinds of things about a washed out German Shepherd. And if you knew his prior bite history, and he had attacked a dog and this and that, and, you know, and who gives away their dog and who rehomes their dog, like the whole thing, all of it. I mean, he could be great. But
I don't even know if you get that far. I don't know that he even clears the threshold, if there's a Daubert hearing on him, that he is credentialed. I mean, I mean, good, we'll have to hear what he says, but I don't know that he has the right skill set for this. It doesn't mean he's not skilled, but, you know, this is medical evidence. He's a PhD behavioralist.
Yeah. It's interesting because they don't call him doctor. I was wondering if they called him doctor in the exchange. They don't. They just say copy of CV of James Crosby. I was wondering if they called him Dr. James Crosby. They knew that he was a doctor somehow.
You're going to get up and say, my name is Doctor, and even the DA is uncomfortable with that, because you generally don't do that.
Jennifer is agreeing and says, instead of proving these wounds were not result of a dog, should the Commonwealth not focus on proving they were the result of being struck by a vehicle? Yeah, I think so.
Yeah, but how do they do that? I mean, again, he's got a head injury, but, you know, they're telling you that he got whacked in the arm such that he got the, you know, dog bites or not dog bites, and somehow in a miraculous feat of physics and poor engineering or whatever, that a polycarbonate taillight, just from that impact, which didn't even bruise and anything, somehow shattered a taillight into 45 pieces. And I would expect at a retrial that there's a lot more emphasis on that, about the science of the taillight and the polycarbonate. I mean, that's supposed to be generally a shatterproof thing.
Crash Daddy's built a cannon and shot a cocktail glass at it, okay, with velocity that, you know, Cooper Hall couldn't even define what velocity was, and it didn't shatter. So, come on. Where are we going with this?
You take like safety goggles, okay, things like that. Those are made of essentially polycarbonate or something similar. And the whole purpose behind safety goggles, instead of wearing regular glasses, is because they're not going to shatter. So how is a human arm that doesn't even get bruised, doesn't get fractured, doesn't get broken, on a 20-mile-an-hour impact, going to shatter what is supposed to be a substance that is not supposed to shatter, and to the extent that it does get damaged, is supposed to collapse within, which, oh, by the way, is kind of what, you know, the testimony was, or you know, from hitting John O'Keefe's car. I think you'll see more about the nature of the taillight in terms of the science of how it's made up at a retrial, because it just doesn't seem to make sense that his arm would not be so bruised and bad. I mean, the blunt impact on the bone, you would think, would just fracture it if that happened, and it didn't.
It would fracture it. You'd have torn tendons. You'd have ligament damage. You'd have a dislocated shoulder. You'd have a fractured shoulder. I mean, your arm could be torn off. They're at 24 miles an hour. I mean, come on.
And I feel like if you, not that you would do this, but if you went up and tried to punch that taillight, and assuming you didn't break every bone in your hand, which you probably would, even if you did it with a boxing glove, it's not going to break.
No, it's
not going to shatter.
It just won't.
It won't.
It just won't.
Thank
you, Sarah. And thank you to Sherry. I put your super chats up. We won't have time to read all of them if they're not questions. Sue Mo, thanks so much for your super chat. My opinion, Hank Brennan has been hired by the McAlberts as their defense attorney. They are paying him by promising or owed favors, hence his low wage. Morrissey has been told by them to get rid of Lally and hire their lawyer to defend them, but just disguised as a prosecutor.
I can't.
I mean, this is a good time to point out that our opinions of our viewers are not our opinions, but thank you for sharing your thoughts, Sumo. Can't really...
That's just a bridge too far for me.
Yeah. Thank you, Lisa, for your super sticker. Lana, hi from the UK. Hi to the UK. They're not trying to prove he was hit by a car because they're only worried about defending the McAlberts. That goes along with the other comment. think you're amazing, Melanie. And Mark, you are an absolute legend. Oh, look at Microdots in the chat. Who would introduce sanctions for the inverted video? Is that on the judge when it happened, on another body? What normally should have happened? Great show, guys. Thanks. I think whatever happened at Sidebar, and we didn't hear it.
It could have happened in two ways. Normally, the party that gets screwed by the improper disclosure of evidence and the admission of false evidence, which clearly was designed to mislead the jury, would stand up and say, I have an application. And you would start high and, you would seek a mistrial. This is outrageous and you would certainly ask for any other sanctions, the video be excluded, other evidence be suppressed. I mean, you could go on and on. The judge certainly has the ability on her own to ask questions, which I think she should have. And maybe she did at the sidebar, maybe we'll see. But I can tell you that there isn't a judge that I know that I've ever been in front of that if that stunt had been pulled up would not have said, what the hell is happening in my courtroom right now? Like, we don't do that. And it's just, there's no defense for it, because even if it was disclosed late, you start with that. I mean, even if it was real video, it's already too late. They play it inverted, which is a disaster. And they don't even tell the other side and bring out evidence through the witness that it was inverted. I mean, everything about it suggests that it was deliberate and designed to mislead. And you can't ignore the fact that it's one, because it would be one hell of a coincidence. By inverting the video, all of a sudden, everyone in the world, with the exception of the guy in the attic who, had the aha moment on the left tail light, every other person in the world would say that's designed to mislead and hide the right taillight, which, why would they do that? It also just conveniently took Proctor off camera when he's kind of, over there dry humping the right taillight. I mean, he's right there. What's he doing? We don't know. The defense theory is.
Well, did you see that picture floating around where somebody did a screenshot? I don't know if I don't think it was Microdots, and it looked like there was a shadowy figure in the background holding a hammer. Right. I mean, I don't know.
Yeah, I don't know. Those videos.
It was a funny meme, but
no, obviously those videos need to be cleared up and whatever. But it's bad enough that it gets disclosed late. It's bad enough that it gets inverted, and in the ultimate coincidence of coincidences, it just happens to conceal the right rear taillight, which should be front and center on display next to Michael Proctor. That's about two coincidences too many for me.
Mm-hmm. And it clearly looked like it was altered. I mean, there's people coming in out of frame like ghosts, and you got and then the taillight piece that looks like it's supposed to be the passenger, looks like there's a big white piece missing, and then it kind of like that white thing moves. Like, I'm sure Microdots has done a video on it, but
you can't also look at this in isolation, because then you say the library missing video, which is there's no explanation for. The whole thing about the car was taken at 4:15 instead of 5:30, like Proctor repeatedly said. The taillight pieces that got found. I mean, none of this is in isolation. When you put all of this together, I mean, I think the inverted video is the key component of this. It reeks of, you've got to be kidding me. And again, they don't have to prove that. You're on a reasonable doubt standard, and you just add fact after fact. The phones that they got rid of before the preservation order, the butt dials that they lied about, clearly the Google search, whether you believe it or don't believe it, even though it's 5 minutes apart from all the other things, tell them the guy never went in the house. When did he become the guy? Right. I thought this was our good friend.
Well, remember, they were in like the circle of their little circle, their little family circle of trust.
They're looking in the wrong house. They're looking, but they're looking in the wrong place. We're going to go write timelines. Let's go sit down with, John's mother and make sure the timeline is clear. Carrie's telling them everything. She's telling them everything. Why does that concern you? What is everything other than you and Jennifer McCabe and Karen Reed went looking for this? You could go on and put one little piece of evidence next to the other one, next to this. You haven't even discussed the ARCA stuff. And at the end of the night, I mean, you just need reasonable doubt. All of these facts probably standing alone should constitute reasonable doubt or damn close to it. All together, it's overwhelming. It's suffocating.
In the regular reality, yeah. In the alternate reality, I have no idea what went on inside that jury room. We're never going to know.
Well, I would assume
unless somebody speaks out. I mean,
well, I also assume, look, these are the most experienced lawyers you're ever going to get. I mean, they've tried the biggest cases. They know what they're doing. I assume part of their reflection is also going to be jury selection. Did we make some things that maybe, we should do differently? I don't know. I mean, I would assume that that's a serious thought, though.
yeah.
If you had 8 or 9 people who were at least willing, based on what they heard, to believe that something must have happened or they didn't understand the law, either way, you have to be saying, like, what the hell just happened here? Like, this is crazy.
Virginia says, in my opinion, she's keeping it in January, so not many supporters. Well, I don't know. There were a lot of people that came out in the cold yesterday, so I don't know that the cold would keep any supporters away, but I don't think she can keep it.
I don't know if that's true or not, but I think by human nature, yeah, there's going to be less people because, first of all, would any of us, I would assume they're going to go to the real courtroom this time. I would assume.
Well, you can't if they have the jurors are looking at the back of the witnesses' heads.
I got to tell you, that may be something, I don't know. My thought initially was you go to the small courtroom because you got to see them. That courtroom is terrible. But if
there's other courtrooms in that building, though. I mean,
the big one's nice. The big one's nice. It's actually nice.
It's beautiful. Remember the ceilings? We went in there and took a peek.
Yeah. Well, I even appeared in there, actually.
Oh, but that's right.
Remember that? If you stay in the little courtroom, then there are no seats. And now people are going to stand outside in the freezing cold from 8 a.m. to 5 p.m. And by the way, in January at 4 o'clock, it's like half pitch black, 18 degrees out. There's not going to be as many people. The hardcore people, they'll go, but it's impossible that there will be as many people in the middle of winter as there would be in spring into summer.
I'm surprised also that nobody argued that we need an adjournment also because we don't know what the appellate court's going to do. So, I mean, that's another reason, but
that's what I was surprised as well, that at least there wasn't some statement by the judge just acknowledging all of this is conditional upon, of course, what the high court tells me. And
I think she wants everybody to keep moving, keep chugging this train down the track. And in the end, she's going to, but she'll wait very late, I think, to give them the adjournment because that's what happened last time. If I recall, the original trial date was supposed to be, I think, in March. And then she wound up pushing it like maybe a month or so, but it was very last minute.
3,000 pages, couple weeks,
Yeah, it wasn't, she didn't push it for that long.
And you're also talking about evidence that changed the trial and turned it on its head. I mean, based on what they learned. I mean, so many things had to be adjusted and changed.
Lisa, when Scanlon came forward with information about Chloe, why wouldn't the Commonwealth have dental impressions taken of Chloe's teeth to compare marks on John's arm? Because they never wanted to ever admit that it was a dog bite.
Why? Because they don't care. And no, you pin it on the girl. I mean, they had their suspect and they don't want to know.
They had that ruled a motor vehicle homicide by within 16 hours.
They had the car set up to be towed prior to ever interviewing and speaking to Karen Reed. If there's one fact that tells you this gig was up right away, the day of it, that's it. That's all you need to know.
The other night we saw for the first time, at least for the first time, I saw the search warrant attached to, the affidavit is attached to the search warrant application for Karen's phone, which was dated something like February 2nd of 2022, which, by the way, was the same day that Julie Albert wrote a text to Courtney Proctor saying, when all this is over, tell your brother I want to get him a gift, which was the same day of Karen's, I can't remember if it was her arrest or arraignment. February 2nd, 2022 was the day that Proctor signed that affidavit to get the search warrant for the phone that he already had in his possession, that he took from her. He said in the search warrant affidavit at 5:30. And he said in the affidavit for the search warrant for the vehicle data information that they took the car at 5:30. We have now come to learn that is either a lie or a scrivener's error or a typo or something. but I didn't know about this. I don't remember it being brought out at trial. I don't know if anybody else does. Was that the first time that you saw it too?
I've never seen the search warrant application, and I actually remember several months ago talking to you or somebody else. I don't remember asking then. It must have been during the trial, because if I recall correctly, the trial testimony was, "Yeah, we're going to have to take your phone," which by the way, even the Twitter lawyers probably recognize this. There is this thing called the Fourth Amendment and the right to be free from unreasonable searches and seizures, and that generally you're not allowed to just go demand things without cause, and that's not consensual. That's, there wasn't a warrant at that time, and we just saw the warrant was later. You need probable cause to seize, and you need authority to do so, and I don't think they would have had it at that time to literally just take it based on what they had, and they did, and then they got a warrant after the fact. It's like they papered over the search by getting the warrant, and then they do what they do, and
both the phone and the car. In fact, the warrant that we saw the other day was not even the warrant to seize the actual vehicle. It was to seize the Verizon data that was inside the vehicle. So I would love to see the search warrant on the vehicle.
Right. And of course, to me, in the warrant, the most troubling part is the 3 or 4 references to 5:30 p.m.
Yes.
Which this nonsense about a scrivener's error, that, first of all, that's the best they could come up with. That's dumb. Mm-hmm. But the fact that they, Proctor came up with the, same scrivener's error 4 times is impossible to believe. There's no question they wanted it to be at 5:30. And what I don't understand, and again, I don't know what hearings were granted before the trial, the timing of the warrant and the apparent multiple instances of perjury in that affidavit by referring to it at 5:30 would have played right into the defense's hand, that was Proctor deliberately lying in order to push the clock of opportunity back, such that they would have had to have been in transit at 5:45 or whatever it is, that they could not have planted the taillight. And, they got exposed that there's the tow truck that shows the car going on at like 4 something.
4:15 around there.
To show the taillight, at least arguably, maybe people disagree about this, not being in the condition that they claimed. And then, as was pointed out by many others too, and this is something that I think a jury, this is just basic common sense. At 5:30 in late January in Massachusetts, this pisses off a lot of people, but it's pitch black. Mm-hmm. And you look at the video of that car getting towed, it's daylight. And, that was on January 29th at about 4:15. And I'll tell you one thing I wouldn't want to be if you're the prosecutor, and maybe this is the reason they want to try the case in January, because I would find out a way to make sure the jury knows every damn day in late January what the sky looks like and how depressing it is at 4:15, 5:30, and that's a very simple way to demonstrate that there's no way it was 5:30, and there's no way Proctor could not have known that just based on what the condition of the sky would have been. Now that you've seen that affidavit too, I have no idea why there was never a Franks hearing sought or ordered, but I don't know when the defense learned about any of this either. But you have a right to challenge a search warrant under the theory that the police officer affiant lied, perjured himself deliberately. And it's Michael Proctor, so of course he did. Look at everything else he did. This is a bombshell that just kind of floated up here the other day. And to me, this is a very big deal. And if Proctor testifies at the second trial, he's screwed. I don't think he will unless the defense calls him. But scrivener's error 4 times.
Yep. Again, thank you for validating me, because I had a meltdown when I just came across it the other night, and I'm like, wait, 5:30. He lied. He lied in his affidavit for a search warrant. That's a really big deal. Tell people what happens when the officer lies to obtain a search warrant.
Well, everything gets suppressed, assuming it's material and doesn't impact the rest of the warrant. But it's perjury. It's sworn. An affidavit in support of a search warrant is the same as testifying in court. And you get, what are you going to do with Proctor? He is what he is. Mm-hmm. But it's worse than just he lied in the search warrant. He lied again and again and again, and I think it was 4 and again. And each time that he lies, it becomes less possible to be a scrivener's error. So now you start wondering, why did he do that? And then all of a sudden, that taillight planting theory gets more evidence to support that. And you factor in his text messages. He never took a picture of the taillight, and we go on and on and on with all this stuff again. And he is their theory that he's corrupt comes off as certainly supportive of reasonable doubt, if not to any rational people, probably true.
Because the search warrant application wasn't even drafted until 4 days after the illegal seizure of the car and after the taillight pieces began to be found on the evening of January 29th.
Well, the other thing that's interesting, and this is another failed check and balance perhaps in how they do things in Norfolk County, or maybe this is a Massachusetts thing, but certainly, in New York City and other places, prosecutors write the search warrants. They prepare them for the police. And the theory, amongst other things, is that it's going to be done right and actually contain probable cause. But also, it's hard to believe, although maybe this case makes people feel differently, that a prosecutor is going to be part of this. And if they're, preparing an affirmation or an affidavit for Proctor, and he's saying, well, we went there at 5:30 and that perhaps a prosecutor would make, how do we prove that? What evidence do you have of that? And it's like a firewall to prevent corruption. But these guys prepare their own warrants, which is just inviting the big lie to continue again and again and again. And this is why everything in that office is so screwed up. The inmates run the asylum. They let the state police homicide unit do everything. They let them write the warrants, and if they're corrupt, no one will know. They let them donate money to Morrissey. This is crazy. They let them all hang out and send text messages and do all this and, buddy. And it's just mess after mess after mess. And they run amok. And there are so many things that have to change in that place. And these are the kind of things that the candidates running should be trying to fix. They should just end this practice of having these for lack of a better term, fraternity house type environment with the state police literally encamped in the DA's offices. There should be a policy. You can't donate to the DA. You can't, that just invites corruption. Right. You can't write the warrant. We can't trust you guys to write the warrants yourself. We need a firewall with a prosecutor. All of these things. I mean, that's part of the problem with what happens in Norfolk County. Maybe that's why they feel so emboldened to go bully the medical examiner and push this and push that. I don't know, but that's why this stuff happens again and again in that county. There's no firewalls. There's no safety nets that are in place to try to prevent corruption from happening.
And they're all working together. I mean, these investigators are assigned to that office.
Yeah, no, they all
the same players every single time.
When someone is that close and works every single case together, do you really think they're going to be less likely or more likely to look at each other and fudge the line and not? That's right. I mean, I'm not saying you can't have a professional relationship, but when you literally have the same team of police and DAs and they all donate money and eat lunch together all day and do the same thing, and you just let the police run amok, that's a recipe for corruption.
Agreed. Based on the time Lucky saw the Ford Edge and Jen McCabe's 911 call in which she states JOK had been out there a couple of hours per the 911 transcript. Thank you, B Harmony, for the super chat. Is the SJC aware of the January 27th trial date? It may have been in the papers. I'm not sure.
Maybe, but the real practical answer is who cares? They don't care. They'll do what they think is right when they do it. They run the state. They're the high court. And they're dealing with critical issues of constitutional rights and double jeopardy, and they're not going to rush it to satisfy, Judge Canone's calendar. They may resolve it, and the trial may go forward on January 27th. But I can assure you that none of the judges could care one way or the other that a lower court judge says, I'm doing this on January 27th. They don't care.
Yeah, they don't.
And they shouldn't. They have to do what's right. And also, everyone's watching, and they have to lay down You know, there may be precedent here. I mean, you know, one of the interesting issues is, should the judge have asked the jurors, like, which count? I mean, the court's going to have to speak on that, whatever they do or don't do. So this is not a decision that's just going to affect this case. This is going to be a very careful, and they know everyone is watching, so they're going to be careful.
And there are 7 of them, and some of them may agree, and there may be a dissenting opinion, and it takes a long time to draft these things. And they have other cases to discuss too. This isn't their only case.
Really, I mean, again, if you understand, you do obviously, how appellate practice works, this would really be a good case to be unanimous either way, that they be unified about. I mean, you're talking about literally trying, but by all accounts, factually speaking, an acquitted woman for murder twice, which is just, I mean, gross if that's the case. I mean, that's as un-American would get. And if you're going to allow that, I hope you at least have 7 out of 7 who think in good faith, here's why. Because this feels just icky.
Gross is a good word for it. Local wars. I think this case is the poster child for case for justice for we the people. Any one of us could be Karen, and that should outrage everyone. We fix corruption by ending it with accountability. Thank you. Thank you. A good citizen said, Mr. Bederow, if you go on with lawyer, you know, my suggested stipulation, because you can make demands, you know, is that his father be on the show also. Did he ask you to come on his show?
Yeah, it's in the works, actually.
Oh, really? You got an invite and I didn't. Hey, Peter, what's up? Okay, cool. That's cool. Oh, but somebody wants my lipstick color. So hang on a second. Let's go back to me for a second. I'm just kidding. Actually, I don't really know. It's Fenty. It's a Fenty gloss, and they come in several different colors. This is the one that looks the most like rose colored here. Looks like this. Fenty. There you go. What else you got? Anything else you want to talk about before we wrap? Thank you to Marcy's iCloud for the Venmo, who says, I'm hoping the petition to get Healy out of the State House gets heard.
No.
I don't know anything about that. Do you?
No, but I mean, not to be all cynical, but you know, these petitions to the governors and whatever, they don't do much.
They don't care.
No, I'm just being honest. I don't think that does anything.
They don't care.
No.
I'm looking here for some other questions, but I do not see any at the moment. So what else you got?
What else do I have? I don't know, but it's now, 4:38 and it's getting dark. See, I mean, it is. It's dark. Everyone smash that like while you're here. We promise that the MSP will not get your DNA. We can promise you that, I think. I don't know. It's for now, it's pretty interesting that she wants to keep the trial on the schedule they're on. And that would be interesting because it could be a little bit of a fire drill. It sounds like. I thought the prosecution was going to be more ready to go. Right. But he hasn't even watched the trial yet. He doesn't know who the witnesses are. And he doesn't know procedure, apparently, in Massachusetts either. So, there's that. But even the experts, like, they don't even know. I mean, you're pushing forward and you're gambling that, this expert is going to look at the telematics. As he says, it could be inculpatory, it could be exculpatory. We don't know. But, if it turns out that it blows up the whole case, then what? I mean, you'd say, well, that's the end of it. But the problem is, when you got the ARCA stuff, you'd say, now what? And they say, nothing. What's for lunch? Let's try the case. When all the Proctor stuff came out, you thought a reasonable DA might have second thoughts. No. In fact, not only did they not have second thoughts, they called him as a prosecution witness, and he was willing. I mean, how crazy is that? The whole thing blows my mind. Knew about him. They called him as a prosecution witness. I just felt like they called every single person who ever walked by 34 Fairview in their lives. Like the sheer number of witnesses called by the prosecution was completely ridiculous. There was no need for them to call anybody, in my opinion, that was in 34 Fairview until rebuttal. Because if he never came in the house, why do you need them in your case in chief? You don't. If the guy never went in the house, why is Brian Albert being called to say he never came in the house? It also has been more powerful for them too. The defense gets it out there, and then you finish with the last word, essentially, from what you believe anyway. I mean, I didn't find those guys very credible in what they were saying, at least as it relates to the electronics and that stuff. But yeah, you call them after the defense case, and if you want to march them up to say, look, we didn't see anything, we don't know anything. It was a strange way to try a case as a prosecutor on the defensive rather than proving the case. I mean, if you recall, you didn't really hear evidence that allegedly was going to prove her guilt for several weeks, which is it was odd. But
Dina says if it does go, we'll be out there. The supporters will be out there. Dina, we ain't got no quit. Doesn't matter how cold it is, right, Dina?
No, but you know, some people may be older. I mean, listen, I'm not saying
the numbers will shrink. I think we could agree that they'll shrink a bit.
You know, there's a reason why not everyone likes to go to a football game in January and, you know, a cold weather place, because it's next week.
Next week, Mr. Bederow will be back in Massachusetts. Melissa?
We have court next week on you know, the other thing. That's what we call that, the other thing.
The other thing? One
of the other things, because, you know, there's so many.
Just one. Okay, Karen Reed Peeps wants to watch the documentary How to Fix a Drug Scandal. Netflix's exposes corruption at Massachusetts Crime Lab. That's interesting. Thanks, What If Clever. Appreciate you. One step beyond you. Thanks for the 10. I want to grow up to be Mark Bederow. That I'm older than him just complicates the issue, but I'll try.
Thank you.
Did you see the breaking news today that Massachusetts SJC is looking at government employee and a brothel? The government employees want their names redacted. Oh, well, that could, who knows if that could tie in here at all.
If the names come out of, you know, the Johns in that case that everyone's talking about, and some of them are government employees, I mean, obviously you can speculate all you want. We don't know. If some of them overlap into this, well, yeah, that's potentially, wow. But we don't know that either. I mean,
no, we don't. I mean, but wouldn't that be a weird twist to this whole weird story?
That would be huge. But I mean, again, we don't know that.
This is a great question, Little Cupcake. Why can they ask for another Daubert hearing when for a witness that's already gone through that process?
I'm learning that in this case, there are a lot of things that are kind of unconventional and weird. And it is weird that
except for asking the jurors if they're guilty on all or not guilty on all counts, or if they're hung on all counts. True. Except for that.
Normally, when you have a Daubert hearing, just because it was a few months earlier and the witness established their bona fides with relevant evidence and credentials, and it's not scientific gobbledygook, you know, it satisfies, you know, the necessary standard.
Lampron.
Right. Then you are allowed to testify. Apparently, you know, they have a different prosecutor who has a different field. But I mean, to me, what I don't understand, I go back to this, like what feels like 4 hours later, the judge just basically says, well, let's bring in Dr. Russell and do it. Like, it's just granted sua sponte. What the judge should have said was, I did this before, okay, and I'm open-minded to doing it again, but can you make an offer of proof? What's the problem before I haul a witness from California and haul these lawyers back from California to make the same argument that I've already rejected? And she didn't do that. All she had to do, I think, is just say, tell me when, I mean, I think what Brennan said was, we don't think she has the right skill set for the issue. Okay, that's an opinion. Tell us why. Like, what's your problem with what it was? If, you know.
Well, if he didn't know her name, I don't think he would even know the answer to those questions.
Well, then he shouldn't have made that representation then. I mean, this is the problem. I mean, if they have to haul her back for essentially the same examination and the same ruling, that, I mean, again, I know she picked her own lawyers, and the fact that they're from California, you know, you don't get special privilege, but you don't have to make it harder either. Okay. You don't have to like make it more difficult for the sake of making it more difficult. There's a reason why she picked those lawyers from California, because they're good. Okay.
Well, she's already 5 million in debt. So what's a couple more, you know, tens of thousands by forcing her to not only, you know, a wasted trip for yesterday, in which nothing was decided from the bench. Exactly. Nothing was decided.
Nothing was decided, but again, I'm not saying she's going to exclude the witness, but I don't know why she wouldn't have just said, what's different? What is changed since you last made this application about Dr. Russell? I mean,
right.
I mean, everybody knows that she certainly worked in an ER for a million years, whatever she said. Everybody knows that she had extraordinary, I mean, granted years ago, extraordinary experience about treating people with dog injuries or scratch or animal injuries. And everybody knows that she wrote articles or a book,
Peer-reviewed papers, yeah.
Peer-reviewed papers about this. So she's clearly qualified. It's clearly relevant to the defense, particularly since I say people, you got to get into Massachusetts brain, the Commonwealths, not the people, the Commonwealths. Own medical examiner expert has, I mean, I would make this argument if I'm them, has already conceded that her testimony is not going to change. I don't know what caused these injuries. I can't exclude dog bites. I can't exclude dog scratches. So it's relevant. She's competent. She's qualified. And just because she called a colleague she knew who knew Jackson and that's how they found her, that's no different than hiring all these other internet experts that the prosecution has, right? No different at all. The fact that, Lally tried to trip her up about whether her free Boston Globe subscription was 3 months or 6 months.
Right.
Are we kidding here? I mean, that's the gotcha that she's somehow not credible. This is.
She's board certified in emergency medicine and forensic pathology. She was a chief medical examiner in California. I forget which county, but it was like the busiest county. And I forget how many autopsies.
LA County is
it's
like New York. It's horrible. I mean, it's like crazy, and it's bigger because it's so much bigger.
Over 35 years of experience. I don't get it.
Look, they already heard this application. So again, unless there's something different. And I mean, look, Brennan has a right to make an argument. He said, I don't think she's qualified, or words to that effect. I don't understand why the judge would not have interjected right there and said, okay, why? Before I burden everyone, including the witness, by the way, before I burden the witness to schlep out here, tell me what's different. And instead, see you in whenever and bring her out.
And tell me why they couldn't do it the same day as they were coming back to hear the other motions, by the way. Why do we have to have two separate dates? Why can't we do everything on the same day and just make it easy for everyone? Have Karen incur one cost instead of two separate costs with travel and everything else.
There's no rule against having pretrial proceedings that go a few hours instead of 20 minutes.
Are you worried that the chips could be tampered with or even different chips?
I'm not worried.
Thanks, Marie.
I'm not worried, but it's pretty obvious that Alan is.
Well, yeah. And also the Commonwealth is the one who's been in possession of this evidence, since the beginning. So,
listen, the fact that the defense is saying we want to do this, but we don't want their expert to do it because we don't think their expert is qualified is very telling, or that is one hell of a bluff. Okay. And that would be a reckless bluff. That's not a bluff. Okay. And I don't know what they know or what they're happy about or unhappy about. But you don't take the position of, I double dog dare you to do this, and I want to help you do it right because it's going to help us, is what he's essentially saying, unless you want that data. So, don't believe everything you see on Twitter from people who are saying they're running scared and screwed. Nobody knows what's on that, but they seem highly confident that they want to know, but they want it done right, and who wouldn't?
And in fact, Brennan is the one who said, he said, we want to make sure that nothing was deleted, destroyed, or tampered with. And it's Brent. And I'm like, it's been in your possession the entire time. This car has been in your possession from January 29th, 2022. So if you're worried that something was tampered with or destroyed or deleted, what does that say about how confident you feel with your own people guarding the evidence?
I mean, you get a lot of mixed. You get a lot of mixed signals. I mean, on the one hand, when he says, I don't know what's on it, and it could be exculpatory, it could be inculpatory, that's a proper thing for a real prosecutor who's going to follow the facts to get to a conclusion to say. But on the other hand, they submit these filings that are all conclusory that, she absolutely did it. And it's a mixed bag in terms of what they're doing, what they're saying. And they seem all over the place. They just seem cluttered. I mean, the hearing yesterday, the word that comes to my mind, it seemed cluttered. It seemed disheveled.
Well, why should we have consistency now? Is everything all of a sudden going to be Bates stamped and you know, we're going to all of a sudden it's just going to be consistent throughout? I don't think so.
He is right to Bates stamp it.
Yeah, no, I agree. It should have been done the first time.
Absolutely. And, you know, that's got to be humiliating for Lally and the other one. Like, how do you not do that? That's what real lawyers do when you're talking about discovery and disclosure of thousands of pages of documents. How do you know, do you want to have this come back 10 years from now where someone gets convicted and says, I didn't get this, you know, document? And how do you prove they got it if you don't even have proof of service of it? I mean, this is not rocket science.
No, but they make it out to be. Thank you, Uncle Fredo. Yeah, I'll be sure and take a look at Nathaniel Brown's case as soon as I have a free spare second. Thank you. Thank you so much for the suggestion. All right, I think we got to wrap.
Yeah.
I think we got to wrap. Olivia says there's no need to do more chip offs. Anything you want to say in closing? Anything you want to know or talk about or add?
This was interesting. It was funny running into you the other day. That was.
I know. We had a nice lunch in Little Italy. I was telling people.
Yeah. Which is, you know,
to catch up.
So many places have changed though. That whole area. I mean, all my Vietnamese and Chinese spots are gone from.
I know.
But yeah, no, it was fun and this was interesting, and you know, we'll see what tomorrow brings. Probably more filings and more banter for discussion.
Well, you know, tomorrow's Friday, so of course there's going to be probably something huge to dump tomorrow. So yeah. We'll
4:55 exactly.
Yeah. Thanks to the moderators for keeping it classy in here today. I know this is not an easy case to cover. And Sarah, I'm going to thank you again for gifting those 10 memberships if I didn't thank you already. And you guys know what to do. Smash the like, share the stream out, hit the button, be sweet. And also, just be safe out there, you guys. All right.
Okay.
Peace. I'll see you soon.
Okay. Bye.
Bye.
Sure.